Yeah, AI just hit, so
And then
that's
she
scary.
does it all day and she was having trouble.
I'm putting it up right now.
Oh, thank you. No, no worries. I'm gonna just hit some video and be out of your hair and on to the next.
All right.
Never. That's.
All right.
I just go the other one down the street.
There you go.
The big house.
Now you can say you've been here.
You've been here all over. Thank you.
Got somebody down there.
Okay,
I was
that's
gonna-
done.
Up here. Down
I noticed
there.
a few people down there at 8.
All right. Well, thank you, everybody. I see we got a fairly good attendance virtually. And we do have one individual here that showed up so far for the in-person. Anyway, once again, I'd like to thank you for coming. All right, we put together a PowerPoint. I was just going to kind of go welcome everybody and thank you for taking the time to partake in this stakeholders meeting. Hopefully there's not a huge disruption in your day-to-day operations. There is going to be some changes due to the unfortunate events that happened October 10th last year. And I think we all know that happened up at the Molly Kathleen. So unfortunately, change, is hard to stomach sometimes, but sometimes we need to do it to make sure we're in check. and in line with our statutes, okay? To start off, just want to make sure for Jack, since he's new in this building, in the event of emergency, we've got 2 exits down the hallway. They're going to be on the north side of the building. The closest one is going to be on this west side here. Event of emergency, we'll exit down the stairs. If it's not accessible, we'll go to the next set of stairs, and then we'll go out the front door, and we'll go out the doors. There's doors on each end of the building, across the street, okay? So hopefully we don't have to deal with that, but we just want to cover that. Restrooms are on the south side of the building. The men's is on towards the bottom, towards the back. Okay. All right. So what we'd like to do is we'd like to do a brief introduction just so everybody in the room knows each other. Obviously, I think I know most everybody in the room, but there's Jeff and Russ. Jason probably don't have the same kind of working relationships that we all do. I'd like to go ahead and introduce myself. My name is Brandon Neal. I work for the Division of Reclamation, Mining and Safety. I am the Mine Safety Program Manager. And we are basically the ones that are proposing these rule changes. All right.
Good morning, everybody. My name is Russ Means. I'm the Minerals Program Director for the Active Mines Program.
Good morning. I'm Jeff Huey with the Attorney General's Office. I've been the attorney for the division for a number of years now, and I assisted on the draft regulations here. So thanks, everybody, for joining us.
Yeah, good morning. Good morning, Jack, here in person and everyone online. My name is Jason Music. I'm one of the active mine program directors along with Russ for the coal regulatory program. The mine safety and training program sits underneath our program. So yeah, Jeff, myself, and Brandon have spent a substantial amount of time reviewing these rules, modernizing them, getting up to speed, and hopefully not only are these going to be beneficial in terms of increasing our mine safety, our tourist mine safety, but also helping the tourist mine industry out in terms of giving a little bit more straightforward approach and modernization to those rules. Turn it back over to Brandon.
I'm going to go ahead and go through everybody else. Go ahead if you want to just do a quick
I'm
introduction.
Jack Morris. I'm the owner and operator of the Last Chance Mine in Creede, Colorado. The mine is come into my possession in 1998. I've spent the last 27 and a half years restoring, preserving, and opening it to the public. And so far, I've had a good working relationship with you guys. I'd like to continue that. Didn't see a lot of it in here that I need to address. So probably my comments will be short and sweet.
Okay. Then we'll go online here. We'll go ahead. Tom and Hank are online. You guys want to introduce yourselves real quick?
Yeah, my name is Tom Rice. I've been with the state as a safety specialist trainer and mine rescue coordinator now for a little over 3 years. And I go around and do some of these tool mine inspections. And it's good to be able to meet a lot of the folks with these mines, these tour mines, and enjoy spending the time with them.
Okay, thank you. Hank? Can't hear you.
That better?
Yeah,
Good morning,
much better.
everybody. Nice to be here with you this morning. Nice to see all some familiar faces and some new faces. Look forward to today and some interaction with you guys. I know some of it may present a burr under the saddle. I hope we can work that out amicably. And yeah, it's good to be here.
Thanks, Hank. Bill Jones. We can't hear you there, Bill. All right, we'll come back to you, Bill. Let's go ahead and go to Randy or Chris.
My name is Chris Stone, representing the Heidi Gold Mine. Thank you.
Thank you. All right, I'm just going with what I can see. Ryan,
Ryan Chadwick, Compromise Mine.
thank you. All right, Fred,
Fred Wilson, Smuggler Mine, and also the Compromise Mine.
thank you. Chris, first. All right, we'll
Still
come
on
back.
mute, Chris. Everybody, just as a blanket, you gotta turn your mute off there.
I guess. Can you hear me?
We can.
You can?
Yep,
Got you now.
But can you see me?
yep.
Oh, okay.
I like the view in the background too.
Well, you know, what's kind of uncanny about this is I'm only going to be here for a short few minutes because I've got to go underground with these school kids. So, you know, anyways, I'm here, but I'll hand my phone over to Jay
Okay.
so he can also participate.
All right, so it'll be you and Jay on the same. Okay, thank you.
Yeah, we'll be on the
Greg,
same.
sorry.
Yeah, Greg Sterrett with Capital Prize Gold Mine, Georgetown, Colorado.
Thank you. Jim. All right, we'll come back to you, Jim. Dave.
Yeah, it's Dave Mush, Phoenix Gold Mine and the Centurion. And thanks for letting us participate.
Of course, thank you. All right, Bill, did you get your mic working? Okay, that was Bill Jones with the old hunter. All right, we'll
Bill says he's having mic issues and he's with the.
okay. I guess we can keep the chat open in case he needs communication. All right. All right, well, thank you again for taking the time to participate in this. So here's what we've done. We've prepared a presentation and we tried to highlight any major changes, even if they're minor changes, but anything that would change the way we look at things. There is going to be some changes that I skipped over, and we'll have a period at the end that we can
hear you.
take and discuss in case I left something out or we forgot something. But what we want to do is I put together a 39 slide PowerPoint. Okay. After each slide, which there's about 35 that pertain to the rules. And then I think there's like 4 or 5 that don't have any rule changes on them. What we'll do at the end of the slide, we'll discuss that slide. So if we can just kind of wait until we get to whichever rule it is, rather than trying to jump back and forth, going back and forth, I think it'll go a lot smoother. All right. Do you guys have anything you would like to add on that? Okay. All right. So we'll go ahead and get started and then we'll go ahead and adjourn. All right. So the first one is going to be the definitions. All right. So the definitions, I'm going to have to read it off of here because my eyes aren't that great. All right. Is number 5. This one, we've added a couple things. Obviously, you can see the line where it's taken out. Basically, it used to read escapeways mean a passage by which persons may leave the mine. We took away persons and added a person. And then we added there following that sentence, escapeways are conspicuously marked with directional signals reading escape or exit and unobstructed by tools, strenuous material or equipment. Okay, so we added that just a little more clarity. About the only thing that, you know, we anticipate with that, depending on your operation, is maybe the signage. Everything else is just kind of an explanation of, you know, how we want to look, be unobstructed, things like that. All right. And then the 13 and 14, They pertain to the personnel hoisting, which after the events that happened, CDLE came in and realized that they are the ones that need to be regulating that. So those we are taken out. 13, 14 are taken out. And then on number 18, tourist mine means, okay, we took out any mine which primary purpose is for tours open to the public rather than development of material which the owner operator does not have the intent to produce and sell product which significantly affects commerce, and we replace it with any non-producing mine not regulated by the federal government that is open to the general public for tours. And that's going to be in line with what our statute says. Okay. All right. So there's the first thing. Does anybody have any comments or concerns regarding any one of these definitions up to this point?
I suppose 18 is going to go into the later on issues we'll have with not being able to file for an NOI, for instance, with the mine itself. I mean, I suppose it's going to get discussed later, but it does seem to bridge into the discussion on how much prospecting you could do on a tourist mine. I mean, you're basically by definition rolling it out right there, which may or may not be feasible.
I think this is Jason Music. I think right now is probably the appropriate time to talk about it, simply because this is pretty much the only spot where we talk about this definition of a tourist mine and how we are going to define it based on statute. So feel free. This is the spot. You know, ask any questions you have on NOIs, dual use permits, active mines permits, and how those interact with tourist mine permits.
Well, my first comment is it doesn't really allow us very much time to reflect. In fact, the whole process hasn't allowed very much time to reflect on the rule changes that have a major impact on us. You know, you guys have had a year to deliberate and produce. You're trying to institute these, giving us approximately a month and 2 days from release, maybe a little less than that even. So my first comment would be that, you know, we could certainly check this as something that we need to look into more, but to think that we're going to get it adequately decided here in the next 5 minutes, I don't think is a reasonable expectation, which also gets me to one of the last comments here that you mean to implement these by November 19th. I don't see that as feasible whatsoever, frankly.
Sure, completely appreciate it, and we totally recognize that this is kind of a nuanced situation. Okay, these rules. What we have to understand is these rules on November 19th, if they're promulgated on that date, we're not going out to tourist mines and putting a heavy burden on tourist mines. It's just not going to happen. With regard to this specific rule, we needed to make sure that the definition of a tourist mine reflected what's actually in the state of Colorado, the actual statute for tourist mine, which our regulations did not. They were in conflict of each other. And so that was in conflict of state law. So this definition is now mirroring state law statute. Now, when it comes to a prospecting permit or an active mine permit and a tourist
Can
mine,
I interrupt there?
Sure.
I mean, this is an instance right here. What state law are you referring to?
Sure.
That's something I'd like to review,
Sure.
and I would like to have time to review it.
Yeah, we can give you that.
It's just
that
simply
citation.
not too much to ask since we're the ones being governed by it.
Yeah, and I'll jump in. This is Jeff Hugh with the AG's office. And like Jason said, the idea here is not to fast track these rules. It's to try to implement them obviously as quickly as possible. Some of the intent here is to get these in place before the tourist season starts in 2026. If that's not possible, if we do need more time, if folks need more time to provide comments, that's something we can consider. I think our ask is, again, that we're not delaying just for the sake of delaying. 30 days for the kind of the changes that were made here, although they look like they're significant changes, there's really not a lot of kind of in-depth.
It's speculative. Some of them are very significant, at least in regards to my mind.
And with specific to the kind of the dual permitting issue, the definition that we've kind of pulled into these rules, it's 3420-102 sub 12. That's where that you know, any non-producing mine not regulated by the federal government that is open to the general public. That's in current Colorado law. That's not something that we have created just for these rules. We've kind of incorporated them here because it better fits the working definition of tourist mine, or at least what the division believes tourist mine should be identified as. I think probably at the start, it's important to note these rules are not going to apply retroactively, meaning if you currently have a dual permit, if you've got a tourist mine permit and either an NOI or an active mine reclamation permit, this isn't saying that you can no longer do both. It is saying from a certain point forward, when these rules are in effect or implemented, the division will no longer authorize dual permitting. But if you currently exist in a dual permit situation, you can remain as such so long as you continue to comply with both the tourist mine rules and the mineral division rules, as well as for those of you that are on the call that do have dual permits, you're likely aware of board policy 20.2, which is specific to dual permits with tourist mines. It has some categories and criteria that you have to qualify or satisfy in order to kind of maintain that dual permit status. So I think I wanted at the outset to make it clear, this is not making you choose a lane if you currently have both permits. It is encouraging you, requiring you to comply with the existing criteria for maintaining both those permits.
Well, the issue, of course, is pretty obvious. A situation like mine, I like the right to open that route later in the future. And basically what I'm hearing is if I scramble and get it done now, I can keep it in and be grandfathered. But now I've opened myself up to unnecessary paperwork since there are no immediate plans to do it. But should things change, and quite honestly, gold is going through the roof. Things may change. Who knows? No immediate plans. We're not saying that, but I want to leave the options open as much as possible. And it seemed like we had a pretty workable solution in place before this. And the tragedy, tragic as it was, really didn't have anything to do with this, did it?
No, and the change of this definition is unrelated to the Molly Kathleen incident. This is something that, as reflected in that board policy, it's something that the division and board have been aware of, that there are some safety concerns when a mine is both operating tours and actively operating or prospecting. That's why the board policy exists, to create some division in those two activities. I think that the division would be open if you've got some written comments or justification for why kind of maintaining the ability to, at some future point, both operate a tourist mine and a prospecting or producing mine, you know, what kind of impact that may or may not have on human health safety at your mine. I think that's the main focus of the board when this issue came up was, you know, how can these two things happen concurrently in a way that is safe for the general public who are on those mine sites. Those kind of safety concerns don't exist at current, you know, non-tourist mines. Just a typical gold mine, silver mine, hard metal mine. They don't have the general public accessing those sites.
I mean, I hear what you're saying, but just as you said, and I'm happy to put it into writing, I'll make myself a note. It seems preferable to just keep the system we'd had in place. I wasn't a party to those meetings. I want to think that possibly Bob from the Hope More, and I'm fairly certain Jay from the Smuggler, of course, Ed Lewandowski represented the High D at that point. But they did come up with some pretty sensible ways to do both concurrently that to date seem to have been working, as I've never heard any issue, complaint, or accident arising from that point forward. So to move forward and say that we're just going to eliminate it, when there really was nothing to catalyze the thought. I suppose I have some issues here. This is again why I think we could open this up to a little bit more time so that we can, like you say, have time for more written responses. And, quite honestly, we at the current schedule, if any of it does come to head and we need to look at it through representation or through an attorney, we need to have time to be allowed to do that. But again, the accident, as tragic as it was, didn't seem to have anything to do with this. So I'm not sure why the board is so adamant to deny the tourist mine's future abilities to move into prospect or an NOI.
Sure. And again, I do agree that's the point of these kind of rulemaking procedures and these stakeholder meetings is to propose regulations based on division experience. You identified some of the mines that do have dual permits. It's my understanding there's only 4 in the state that have dual permits, most of which are not really actively producing a product. And so a lot of it is just kind of, if we were to strike this concept from the regulations, go back the way it was, I'm not sure that, just kind of maintaining an ability to prospect at some future point offsets potential impacts to human health safety. We would like to hear from folks, though, that are interested in that. That is the point of the stakeholder meetings, is to hear these issues through and have these conversations. To date, I know
Ryan, this is Ryan Chadwick with a compromise. Just a quick question. How does it work now as far as you get notification? I guess, Chris, you can help me with this too. You notify when you don't actively prospect while you're giving tours and vice versa, correct? That's
right. I mean, they're written out. Unfortunately, I don't have it here with me. Caught me when I was away from my main office. But effectively, as I remember
Chris
it.
and Ryan,
yeah.
can I jump in here for just a second? Only
Please.
because I have to go underground and I've got 20 kids waiting outside to go on this tour. The dual use permit was created because of the smuggler mine, because it puts us into a double jeopardy system because of our EPA designation as OU2. We created this many years ago because being just tourists, it forces us to actually close it, remove our buildings, remove our rail, remove everything in order to satisfy the EPA administrative order of consent. This was created so it allowed us to A, continue with a little bit of production, and B, be able to continue doing tours. The problem is if this goes one way or the other, the smuggler mine will probably cease to continue on. I don't understand why the state can't allow those that have an existing to use permit to continue. If they do not want to continue giving other mines a dual use permit, that's fine. But I don't understand why the people that currently have one should have to have it removed. Anyways, I have to go underground,
before
guys.
you leave,
I hope.
I was going to say, Chris, before you leave, I want to confirm these rules don't pull your permit. You are grandfathered in, essentially. You get to exist as a dual use permit. These rules will go in effect future looking. So it's going to have no impact on your permit. You're going to have to still maintain that permit compliant with both the tourist mine rules and the Hard Rock regulations. But it's not going to eliminate your permit. It's not retroactive in effect.
Great. That is exactly what I wanted to hear. So thank you, guys. Like, again, I got to take 20 kids underground. If you're still on when I come out, I'll jump back in.
Thanks, Chris.
See you, Chris.
And again, I'm glad that solves Chris's issue, but this Chris's issue, it's not fair. I mean, if I really think is you need to apply the law equally. You're going to pull it, then shut us down, I suppose. Sorry.
Well,
or
again,
allow us to keep it so that we can use it in the future. But I don't want to get into this grandfathered in have and have nots. Can't we just come up with a universal that works? And it seems like we had come up with a universal that worked until with nothing to do with the tragedy, your board decided to make a major change.
Yeah, and obviously this is, again, this particular change is unrelated to the incident at Mollycat Lane. In fact, the majority of the changes in the regulations are unrelated to that incident. It was kind of the thing that led to a review of the rules, but I believe this is the first rulemaking that the agency's done in the tourist rules since 2002, 2003, when they were originally promulgated. So they are long overdue for updating and modernization.
Well, that's not true, because they at least went over them when they added the dual purpose permit.
No, that was through board policy, so it's a little bit different process. That was through the board with more of an eye on the Hard Rock regulations as opposed to the
Well,
tourist.
I'm sure, but you must have reviewed the rules and regulations when you went over that,
There were no
didn't you?
changes. There were no changes made to the regulations. There was no rulemaking.
Yeah, but they were
process.
reviewed, weren't they? They weren't changed. Nobody found an issue with them. We hadn't had a problem.
No, that's
But they were looked at, they were reviewed, they were utilized.
Okay. Again, this is the first time that this agency has done a rulemaking change of these regulations since 2003. And so that's why there are some other just general changes and modifications, modernizations to the rules.
Oh, and I think everybody knows why, but why, the question is, why are the majority of changes away from the issue? Some of these changes are very much, you know, one of them in particular. I mean, you really should, we should have thought about telling the people at the beginning of the tour what should happen in the unlikely but possible event that your guide gets incapacitated. I mean, there's a few in there like that. And there's a lot of this that, like you said, you need to make these changes because you can't hide under the guise of using MSHA's code, because we're not under MSHA. So therein is a majority of changes there, but most of these changes are fairly innocuous and have to do with that. But that major change is as you put it here, the that major change where a tourist mine cannot also be an active or mineral producing mine. That's the one where it comes out of left field, as far as I can see. That's never been one of our issues. The other one in the same ballpark, of course, we'll get to it, is the fire requirements around the entrance. Of course, that's a major issue as well. I mean, I can see why it never was looked at, because we hadn't had any, you know, knock on wood, any conceivably major accident since 2000 ever. I don't think there's ever been one until the Molly Kathleen one. If there's been anything beyond a slip, trip, or fall in this state, I wasn't aware of it.
Yeah, but I think the lot of the reason this surfaced was, like Jason and Jeff both have said, is to be more in line with our statute. I mean, that's really where this change came from. It's at least my opinion.
But where in the statute does it talk about no dual use permitting? That, I guess that would be where I would like time to review. If you could give me those statute numbers directly and allow me the time to read them thoroughly, I don't think that's too much to ask.
Sure. Again, it's the existing statutory citation is 34-20-102 sub 12. It's just a existing definition of tourist mine in the Colorado revised statutes. That's where the.
Sorry, you got that too quick for me to write it down? 34-20.
34-20-102.
And that's in the CRS, Colorado Revised Statutes?
Correct. Yeah, if you just type that in Google with CRS, it should pull up that statute. That's where the non-producing term comes from, is in existing statutory language.
Yeah, I'll check it when, of course, I'm not going to waste the meeting's time and check it now.
No, and again, I mean, this is one of the big issues from the folks that did submit kind of party status request. This was kind of the issue that was flagged by most folks. I think some of it was just needed some clarification that this was not retroactive in application. It's just forward looking. So those with existing dual use permits, so long as they comply with both sets of regulations, those still exist. But obviously, if you've got additional comments, concerns, specifics to your mind as to why the division should reconsider making this change, we're open for all of those types of discussions. That's why these stakeholder meetings are taking place.
Yeah.
Good, I do, and we will. Thank you.
May I interject just to try and answer maybe one question you had? You asked about regulation regarding the policy for dual use, and it is just that. It's a policy. It's not regulation. Correct me if I'm wrong, but I think there was a policy adopted back in September of 2014, if I'm correct. So I'm not sure where that, you ask where the regulation is. I think we need to look for maybe that policy.
Yeah, that policy, it's board policy 20.2 on the division's website. If you go under the rules and regulations section, I think it's all the way at the bottom, there's an MLRB policy tab. And so these are all of the policies that over the years the board has put together, discussed in public meetings and approved. So that's where that tourist mine provision exists. Hank, I'm not sure on the year. I think that sounds about right as to when this issue last came up, but they are board policy. They're different than regulations, which are different from statutory language. So there's kind of a pecking order of what controls, and it always goes statute, regulation, board policy first, or kind of in that order. But this was something that was identified and raised with the board as something that they needed to consider, and they adopted the policy as kind of a way to allow these dual permits to continue with a little bit more scrutiny and oversight.
This is Ken Starrett of the Capital Prize. May I speak?
Yes. Okay.
Thank you. The Capital Prize has been in operation since 1860, as most of the tourist finds have been around for a long time, and many of them are in the second or third or beyond generation of the ownership. At one time, all of them were profitable and operating, or they wouldn't be there to be doing tours. So what I'm wondering is, this seems to have the implication that you can't explore the possibility of actively mining, producing at some later time by first prospecting it, which some of us, as was pointed out, have permits to do that. We're also operating under the state's Voluntary Remediation Act thing, and we're regulated by the federal government, at least to voluntarily signed ourselves up for whatever you can sign up for. So what is the necessity of restricting the ability to look forward to future potential? And something you really ought to think about is these things, tourist mines, are not all that profitable. They've got a good season, let's say Labor Day, Memorial Day to Labor Day, but it's hard to live off of four or 5 months of income for a full year. So why are you trying to pinch? Why is the thought to pinch down on the alternative?
So, and this is the way I see it, and they can correct me if I'm wrong. Nothing says you can't go out and do an NOI. You just can't be doing tours at the same time. Is that correct?
So, well, our understanding, and we've had the NOI since 2008, is that you can't do both at the same time in the same place. But we've got miles of tunnel and more than several entrances. So,
and unless I'm reading it wrong, Brandon, it says a tourist mine cannot also be an active or mineral producing mine. That's clear as day. You're blocking it out.
Correct. You stop your tourists and then you start your production.
That's
Is that
So-
separately?
Yeah,
Okay.
so
I'd like to make a comment there. I agree. When I read the regs that you're proposing, it is a, or you can't do one or other even at a different time. You can't segregate the time. That's what I'm unreading on this thing. And that does concern me.
yeah,
This is,
so that's
this
that's
is kind of the capital prize, and I definitely agree with what David said.
and that's what we have to. It's an interpretation of the definition of a tourist mine. And the term non-producing is the key term for a tourist mine. And so if you are working with an NOI, and Russ can speak to this, Russ is our minerals program director. If you're working with an NOI, by definition, an NOI is non-producing. You're just providing a notice of intent to explore or prospect. So that's why an NOI and a tourist mine doesn't conflict with the definition. Now, if you go into a production phase, then you'll need not an NOI, you'll need an active mining permit. And Russ can speak to the difference between the two, but either one of those, an active mine permit is not a tourist mine based on the definition and the interpretation of non-producing, because an active mine is a production mine. Russ, you want to?
That's correct. And under the definitions of production and stuff, and development, there, those are the things and stuff that we discuss and stuff in the hard rock rules and stuff thoroughly. The issue and stuff here is the definition of production. And, you know, under an NOI, you're not allowed to sell material or anything like that under an NOI. A mining permit, you can sell material. So the conversation about being profitable and stuff like that, totally understand that. But also looking at production reports over the last 5 years or so, everybody's reported no production. So there's an issue and stuff there with complying with current law. And that's part of the question and stuff that we have here is, I totally support active mining operations and stuff, but on the same token and stuff, you have to comply with the both acts. And so with the this definition here, it's just saying that if you're going to be producing, you're going to be selling material, you have to have a mine permit, and under the definition and stuff for a tourist mine, you don't fit that. And in NOI, you can do exploration, and that and certainly in the board policy and stuff, there's a separation and stuff there. So an NOI is different than a permit. And that, so you could go in and do exploration, but you better not be selling any material, because then you're in violation of the active mines and minerals statutes and stuff.
Yeah, I have a question.
Yes, sir.
Pertaining to this and the NOI. Now, my mine is probably a little bit different than some of the other guys' mines, and some of them I know about, some of them I don't. But our mine complex is very broad and very deep. We're operating on one level. But currently, from my opening date about 7 years ago with one mine tour, we've expanded. We've expanded into 6 different mine tours now. Each one has to be cleaned, restored, preserved, brought up to standards. The problem with that is the removal of the material that I'm having to take out was put in there 100, 130 years ago. And some of it has what would be considered today mineable material. We don't use it. We use it as backfill, stabilization, behind cribbing walls, things like that. But if the metals keep going up, and I'm not sure where Colorado ranks in the rare earth minerals. This is a whole nother ball game that all of us need to think about that owns these mines. If we have rare earths in there that have not been tested and discovered, this opens up a whole new mining era for Colorado. And I'm thinking very seriously about having a couple of companies come in and look at testing our site for rare earth. And this is something that I need to consider when I'm removing this material. Do I need an NOI?
under what you're talking about now, what you're doing and stuff, and that is considered under your tourist mine, you're cleaning things up and stabilizing and stuff. That's all a commercial endeavor. It doesn't fit the definition of prospecting nor mining. In that we have some instances and stuff in that where people have gone in and stuff to stabilize a mine and stuff for different reasons. But I think I remember one and stuff, they wanted to use it as a car garage, right? That's not mining. So what you're doing is a commercial endeavor that's outside of the definitions of mining or prospecting. Now you turn around and try to sell that material, and then that becomes a part of that gray area and stuff that we have to have a discussion and stuff on that.
And maybe that kind of the discussion here has helped clears up some of the questions about, you know, those with existing dual permits and what your requirements are to maintain compliance on the mineral side of things. If you, assuming you do have a permit in good standing, to address some of the kind of the forward looking or the future possibility of converting your tourist mine into a producing active mine. That is what the draft as currently drafted indicates, is you cannot do a tourist mine and an active producing mine at the same time. You can do an NOI, you can do prospecting, you can do some investigatory work to see if it is a mineral that is of value, at which point you may have to make the decision, do you continue as a tourist mine or do you convert to an active mine permit? And that's, again, where the focus on the kind of protection of human health and safety comes into play. Is if you are an active mine, if you are actively producing, if that is kind of your number one business plan, it does raise some different safety concerns for the division as opposed to just operating as a tourist mine. That's where in the board policy, they pointed out some of the, interests of protecting the public while you're operating an active mine.
This is Ken Sherrod again. Why on earth couldn't you do compliance with both at the same time, perhaps at different locations, perhaps to different standards, perhaps to different requirements, and maybe requiring that you don't do tours while you're in the same place that you're doing active mining. But as the gentleman just spoke, many of these old mines were productive and have literally, as we do, as he does, miles of tunnels and more than one interest. Why the absolute, if you do one, you can't do the other?
Yeah, again, I just going back to that definition and the reason why we separate those out on an active producing mine versus a tourist mine is the federal government involvement. And that's written in statute and in this new definition, is a non-producing mine not regulated by the federal government. So if you're an active producing mine, you're going to be regulated by MSHA. MSHA is going to regulate that.
Absolutely true.
That's right.
Some of us, including the Capital Prize, have voluntarily made themselves subject to the federal requirements.
That's great if you did that voluntarily, but when it comes to our statute and what we're tasked to do, the mine safety and training program and the tourist mine regulation, we regulate tourist mine because there's not a federal safety aspect regulating tourist mine. If it becomes an active mine, then we don't have jurisdiction over that mine. The Mine Safety and Health Administration does. And that's the difference. And so if you have a certain portion of the mine where you're actively producing, and then another portion where you're conducting mine tours, MSHA is not going to allow that, much less us. So I think that's the big difference.
Why do you say MSHA is not? Why do you say MSHA is not going to allow that? That sounds more like an opinion than a fact.
Well, I mean, you could call MSHA, but I can tell you that MSHA, the Mine Safety and Health Administration, and Brandon can correct me, being a former MSHA employee, but I can't imagine an active producing mine where mining activities happening is going to allow the public in that mine unless it's an official tour associated with the active mine. Brandon, you could.
Right. Yeah, and I don't know if there's a statute. Tom used to be an inspector. Do you have any on insight on that, Tom? But as far as
I
my
can add
role
one
with
comment.
InShot is
I know
that,
that Denver Mining Club, the DMC, the Ragged Ass Miners, they just did a tour of the Climax mine in there, an MSHA mine.
no, the mine owner can take them in to do a tour, but it's for nonprofit reasons. They can't charge and make a profit off of giving these tours. You can schedule a tour and go to any mine and say, hey, can I go see your operations? And the
So is
mine
that
can take you in there.
MSHA's definition then? Is if Climax were to have charged the DNC, then they couldn't have done the tour? I'm not sure if there maybe that is still a little bit muddy. I don't know. I'd honestly understood that they couldn't either. But then I recently, because I'm a member of the DNC, got invited to do a tour of the Climax molybdenum mine, and I'm 100% positive they're an MSHA mine. So there's a gray area. I don't know.
We're talking about simultaneously tours and mining. Is that correct?
Well,
Correct.
yes and no. I think that's what we're trying to figure out. I can't imagine the Climax shut down production when they let the DNC roll through.
Okay, but on a smaller operation like ours, many of ours that are here today, if I decided to do mine tours from 10 o'clock in the morning till 5 o'clock in the afternoon, that's the end of our tours. Can we start production at 6 o'clock in the evening and go till 6 o'clock in the morning?
Very good point.
No tours.
Right, I'm curious myself.
Very good point.
There's issues and stuff there with, that would have a conversation with MSHA and everything else, because you have an active mine and you're doing active mining activities during the same time. Yes, there may be in different shifts, if you will, but you're still doing active mining at the same time you're allowing people in. So does that create, if you have an unsafe ground condition or a round that doesn't go off that you don't know about, and you bring some people in and stuff right behind that, then what happens, right?
Well, if you're on the route, but let's say, like, just to use a real world example in a hypothetical situation, what if you have the smuggler and the compromise? They're connected underneath Aspen. That's a connected group. But if somebody lit off a charge in the compromise, you'd have no clue in the smuggler because it's a mile away.
Well, and knowing the underground workings and stuff and being flooded and stuff and that, I mean, that's kind of an extreme, right? So, but you're right, you wouldn't know. And that's also a concern and stuff with that of dual use and stuff. If you're on a certain level and stuff with tourists and you have somebody and stuff at another level and stuff mining at the same time, you set off around and then you have rock drop on a tourist and stuff because you're blast. What are you doing? Right? It's public health and safety there. And
well, yeah, and nay. I mean, in what world are you allowed to do that? I mean, you would never have a blast and have a tour go right underneath the blasting area the same day. I mean, that just would never happen, really. I mean, my situation's a little more. I mean, I could see it in different parts, but I don't think anybody would reasonably think that, like, at the high D, we wouldn't like go and do blasts on the face and then that evening let people go to the face. I mean, I guess there really is so much gray area and ambiguity here. It almost seems like a whole nother chapter. And if you're really here to focus on preventing the tragedy at the Molly Kathleen, why are we getting into Pandora's box?
Well, I mean, like Jeff said, that the Molly Kathleen's kind of what struck this whole process. But this process was needing to be done. We just needed to go through and modernize it.
Yeah, but I think you're packing so much into a month that it's not feasible for us to keep up with you, or at least for me to keep up with you. I mean, if you constrained it to just this round, we just worry about the implementations that are a direct result of the unfortunate fatality, and we can come back to it in a later round and deal with some of these more ambiguous issues. Maybe that's a way to more quickly implement the changes that we need to make.
Well stated.
Well,
this is Jim Stark. Can you hear me?
Yes.
Sorry, I didn't introduce myself earlier. I didn't know if there was another Jim or not. I'm not a miner, so excuse my naivety, but I'm a consultant working with Ryan Chadwick on the compromise, more so for the surface ownership. in a potential land exchange, but I have a 30-year history with the government, with the Forest Service and regulatory stuff. And in reviewing all this, again, from my non-mining standpoint, I think the safety regulations seem, I mean, you guys really went through it with a fine tooth comb, and I don't think there's anything wrong with that. I think it's great. I always go back to, through my NEPA experience, of the purpose and need. And obviously your guys' main goal is public health and safety, I would think, by the indication. And it looks like on both sides of mining and NOI and tourist mines, you've pretty well covered stuff. It's that one clause that about active mining that struck out at me, and I agree with that. And some of these guys may not agree with it, but I could see where trying to switch from a tourist mine to an active mine on a daily basis might be a little problematic as far as inspection goes and approvals and documentation. And the compromise is a little different situation because it actually has probably viable tourist mine activities in the winter because it's on a ski area. But it would seem to me that, and keeping in mind that, again, it's really the purpose and need is public health and safety, that if you guys were to come up with something that kept those same statutes, policy, regulations that suggested some seasonal operation that would give you guys time for proper inspections if need be, give the miners time for proper switchover inspections, that would be doable and it wouldn't be going against any regulations. You'd only be doing one at a time if you so choose to mine, or if you so choose to do a tourist mine. And someone else made this comment, but boy, you're looking at the onset of AI and the need for silver and all the new minerals needed for solar panels, et cetera. I don't doubt that within several years, there's going to be a huge demand for minerals that are going to force people to go like, well, wait a minute, as far as a profitability standpoint for the mine owners, they're going to jump right over to mining because it's not even going to compare to tourist mines, which is a little sad because in Aspen, we've got numerous letters of support for what we're trying to do, of the importance of sharing the past with the public, especially in this community, which is completely broken, about mining history, which I think is important to everybody, and what the people did. So I think both things are really important. I think they can be both done concurrently, not in the same period of time, and meet everybody's goals and objectives, providing two good services and providing minerals if needed in the future, and still meet the states and the federals' public health and safety needs to ensure that you guys are covered, the miners are covered, and the public's covered. To me, it's not a huge thing. I was a little shocked by the comment that giving mine tours while there's mining operations, as long as there's no charge, that's odd, because profitability shouldn't come into play as far as regulatory agencies in my history. That if it's really focused on public health and safety, stick to that lane. And you guys have done pretty thorough modifications of those regulations. Anyway, sorry to add in, and if I said something stupid, disregard anything I said that was stupid.
Oh, that's okay. And then as far as, I don't know what MSHA's take is on tours and on that at active mines.
I can expound on
What's that?
I can expound on that just.
Okay.
Stuff. So this is Russ Means with the Minerals Program, and I visit Climax and CC&V and Henderson and stuff for that on a regular basis as a regulator. but I've also and stuff helped tours and stuff with other agencies and stuff to go up and see the mines and stuff like BLM and DOE and that. So for a tour at an active mine like Climax, you have to go through safety training. You have to go through the MSHA protocols and stuff for a site visit, just like any other contractor or whatever. You have to watch the safety videos. You have to sign things. You have to have your proper PPE and all those other things and stuff and that in order to step onto the site. And you have to be escorted and stuff and that, and they take you to specific areas and are aware of specific hazards and stuff there. And they do not charge. And that's the most important thing and stuff and that. Whereas the big thing and stuff here is with a tourist mine, you're in commerce. Your business is taking people and stuff down and showing them around the mines and stuff like that, which is really cool, by the way, in that. So I did it this summer with my grandkids. So, you know, I don't have a problem with that. But to be clear, in order for somebody to go on a tour, there has to be certain protocols and stuff. And the mine spends a lot of time getting things squared away for any tour, not just in that. And you may not have had to have done that for that because they did all of the pre-work and stuff to do that, to be sure that everything that they did complied with MSHA. And that's the most important thing and stuff there. And they didn't charge for it. So, but the difference and stuff is complying with MSHA regulations and stuff at an active mine versus being in commerce and it being your business. And in that there's two different categories there.
This is Ken Starrett from the Capital Prize. One thing that is clear, we seem to be getting off track a bit. MSHA permits tours, and almost every major mining company around the world, and I've been both in Europe and Australia, has some component where they have, or reasons that they have tours, and they do them under the regulations like of MSHA or Australia or Germany. They don't have tours at the same place at the same time that you're doing active mining, but you are there in an active mine. This distinction seems to be a little bit on the far side of arbitrary, and the idea of profit making or not profit making seems to be un-American.
Yeah, Ken, I certainly appreciate that. I think I agree with you that we've kind of gone off on a little bit of a tangent, even discussing MSHA, quite frankly, because these are for the tourist mine rules set forth by Colorado statute. We did not change the statute. That requires an act of legislation to change the statute. We incorporated regulations to meet the statute. And under the statute, the citation that Jeff gave out for tourist mine, the Colorado law says a non-producing, not regulated by the federal government that is open to the general public for tours. Dead stop. That's the definition.
I don't think this is Ken again. No one has any difficulty with that wording. The question is, does that eliminate the ability to also be MSHA compliant, or Colorado Department of Public Health and Environment's also got a piece in play, and we're active in all of them.
Certainly, absolutely. That leads to my point. So if we utilize that definition, it's written in statute in our regulations, we're not going outside of the law. So it's incumbent upon the stakeholders in this meeting to utilize this process or the process leading forward. And let me just caveat this to say, the division is certainly open to waiting on the stakeholder hearing. We can wait. And to Jeff's point earlier, it's not going to be an unreasonable amount of time. We're not going to wait just to wait, but we can certainly delay the hearing until the stakeholders involved in this process can make their own interpretation on non-producing mine, not regulated by the federal government. And then we get that information and we can make a decision along with the stakeholders. Are we going to incorporate this as part of a policy moving forward? But we cannot change the statute, and the regulation mirrors the statute, so we won't change the regulation. But what we can do is address the dual purpose permit under a non-producing mine, not regulated by the federal government. We have that leeway because it's certainly nuanced. We agree with that, but we want to make sure that we're not going outside of state law in the interpretation of these rules.
The question I think that's before you is not anyone requiring, requesting, or whatever you to go outside of these health and safety issues on a tourist mine. I think the question is, can you do other things in a mine, like store whiskey for aging or grow mushrooms without interfering with the tourist mine thing just because you're making money by doing something else?
Absolutely, you can. The only thing that it says is a non-producing mine. So if you're a producing mine, that's where we have this nuance. Are you a producing mine? Do you need an active mine permit because you're producing? Or a non-producing mine open for tours, not regulated by the federal government, so now you're a tourist mine. That's the
point
delineation.
the point that you're making sounds like you're trying to make those mutually exclusive, and they can safely be done, not at the same time at the same place, but they can both. They could be done at different times in different places, different schedules, maybe seasonal tours in the day, mining at night 2 miles away. And some of these mines, like ours and the Smuggler and others, there's a lot of tunnel, and there's more than one entrance.
Yeah, Bill Jones here from the Old 100. Can you hear me?
Yeah, go ahead.
Okay, great. The, going back in a little ancient history, the whole reason the state developed these tourist rules back in 2003 was directly a result of the fatality at the Copper Queen mine that happened, I think, in 1999. And that was during a Halloween event at the mine where a volunteer was killed by sitting on a timber that was rotten. The timber collapsed and essentially in front of the train, and the train crushed this person. And I remember going to some of the meetings on that, and ironically, the state of Arizona did not change any of their regulations regarding tourist mines, but the state of Colorado basically did, and that's why we have the regulations that we have today. So that's just a little ancient history. And I think where some of this confusion comes in is that it's my understanding that under a notice of intent to do exploration, and I've had NOIs in the past with another company that I was involved in, that you don't have an MSHA permit for that. It's not considered active mining. It's not regulated under MSHA. And therefore, under the definition right here of a tourist mine, if you have a mine with an NOI, it's not a producing mine and it's not regulated by the federal government.
Correct.
So there doesn't seem to really be any legal conflict between exploration and NOI activities and the state legislation and definition of a tourist mine, which is why it's really a policy of the regulators to allow both. And it sounds like there's a significant need and desire by the mining community to be allowed to have a potential for an NOI and a tourist mine on the same property. So that's, I think something that everybody needs to be cognizant of and to take under consideration.
Bill, thanks for that. And you're correct. And that's how Jason outlined it as well, Russ as well. NOI, you are non-producing. Once you start production, you can no longer operate under an NOI. You have to convert that or obtain a mining and reclamation permit. And that's where the existing statutory definition, the non-producing mine, that's where we've got the conflict. And so, as they currently exist, folks, the few that are on this call that have an NOI, a dual permit, you're operating under The board policy, those can exist into the future. These regulations also don't preclude you all from obtaining an NOI at some future point. The conflict with current statute comes if you want to convert from prospecting or conducting investigatory work to an active mine. That's where we have the conflict with existing state statute that we're trying to remedy through this rulemaking process. What we can't do is have a regulation that's inconsistent or in conflict with state law. And so that's why we're hoping you, all of you, can also assist us in trying to navigate how do we move forward.
A dimension that you've seemed to miss several times in this discussion is active mines worldwide are conducting tours, be they operating under regulations of MSHA or whatever the national regulation is in Australia or Germany. They're taking people in for tours. Now the question is, are they touring the operating mine? Well, the answer is yes. They're there to see the mine operate, and that's being done safely around the world. We don't have to necessarily exclude that as a possibility.
Again, we're bound by our statute. We've got state law that uses the term non-producing mine not regulated by the federal government. We can't do anything with that.
The definition of a tourist mine is a non-producing mine not regulated by the federal government, does not specifically prohibit the same mine, perhaps through a different entrance, perhaps at different hours, perhaps in different seasons, from being regulated by MSHA in addition to that, like, for example, the Henderson is. And I think most of us on this call have been on tours in the Henderson mine.
Again, but I don't know that Henderson would consider themselves to be a tourist mine as that term is defined in statute right now. They're conducting tours, but they're not open to
the Henderson mine and other MSHA mines do tours on a fairly regular basis to various purposes. For example, they take their customers in very regularly, and you got to be sure that they're taking them in there for profit standpoint. They don't take their customers into their operating mine just for entertainment. They're taking them in there to get some business out of them.
Sure, yes, but again, the division does not look at Climax Henderson CCV as a tourist mine as defined in statute. They are an active mine with an active permit. They're a producing mine.
They're a producing mine, but they're also doing tours.
We don't have any jurisdiction on their tour,
right?
Whether they give tours or not. They're under the active permit. They're not under a tourist mine permit.
They're also not open to the general public and advertising tours. It's generally by invitation and appointment.
Well, not in our state, but for example, Peabody Mining, for education, for local support and whatever, it's on a pretty damn regular basis taking people into the coal mine.
Again, in fact, factually, that likely is correct. We're still bound by our statutory language, and that's our starting point. Is that existing language in
the thing that you're missing is that is not a limiting phrase in there. It just says what a tourist mine is, but that doesn't say that a tourist mine can't be more than one thing at a time.
Correct. It doesn't expressly preclude somebody from being an active mine. However, I'm struggling with the non-producing phrase in that. Yeah. Producing and non-producing in terms of the mineral program and the tourist mine program, they're pretty clear terms for us. In fact, we just did a rulemaking a few years ago where we defined production. So production is now a defined term. And so that's what we're looking for you all. If you have a different read or interpretation of that statutory language, we would like to review that and consider it.
Well, I think what the group that the mining community represents, needs to ask you to focus on health and safety, not on restricting the opportunities in the future for the mine owners.
When that's where this comes from is human health and safety within the mines. That's the section of the statute that language exists.
You can only make that point with some degree of credibility if you say MSHA doesn't do that.
That's what the language says. Again, the tourist mine definition is it's not regulated by the federal government. So these are mines that have no MSHA component to them. That language again exists in Colorado statute under the mines and minerals health and safety provisions. And so the origin of this is all premised on protection of public health and safety for non-producing mines that don't have a federal regulatory agency involved, where those mines are open to the public for tours.
And that role open to the public definitely requires health and safety focus of rather significant value, but it doesn't in itself say that you can't also be regulated to a greater degree, perhaps, by MSHA at the same time.
It says that expressly, not regulated by the federal government, that is open to the general public for tours. Again,
that is limiting to the public tour. Yes, I agree. I think we all do, but that does not say that a tourist mine can't also be a producing mine. It doesn't say that.
Again, I think that the best course of action on this, and we'll see where we get to at the end, but it sounds like, based on some comments we've had, that we may be delaying our rulemaking. So I have to tell you, I would love to hear the interpretation of regulation 18 of a tourist mine, where it specifically mirrors statute for a non-producing mine, and then your interpretation of that compared to a producing mine. Now, I recognize also that if in fact you have a producing mine that has a permit boundary, right? That permit boundary is a certain part of the mine, let's say, that you're producing it. And I'm not quite sure that the federal regulator on safety, MSHA, would agree. But if it's not part of the mine permit, maybe you could operate one side as a tourist mine and the other side as a producing mine. But I'm not clear on how we can move past the statutory requirement of a non-producing mine not regulated by the federal government as a definition for a tourist mine that's written in state law. So if you could interpret that or come up with an interpretation of those items, we would be fully open to hearing that and incorporating those regulations in our decision-making process, and then that interpretation of the regulation into our decision-making process on how these rules are written.
At least that's a step in the right direction.
So I have a bit of a question based on what you're saying.
Sure.
We're talking about 110 true mining permits versus NOIs, prospecting permits. I was looking through your proposed regulations, and I'm not sure I have found it, but I honestly think that you said that you can't have an NOI, and it doesn't make sense to me. How would you ever make a tourist mine into a real mine if you can't have the opportunity to do the core drilling and do the whatever exploration? There should be some mechanism, even if you can only operate as do prospecting part of the year.
Yeah, you certainly can have an NOI and a tourist mine, because an NOI is not producing.
That's what I was hoping you'd say,
yep.
but
Yes.
I honestly thought I read in your regulations that you're proposing that was not going to be possible.
No,
So
that's
what you just told me, is that in the future you are going to eliminate that route.
not an NOI. An NOI is by
I've got to
definition
look at
not producing.
It's just what you actually stated. I'm still trying to find it. I read it not too long
Yeah,
ago.
I didn't see it in there, Dave.
Okay,
I
good.
went through it. I didn't see anything on an NOI in there.
Because, with these metal prices and such, and all of us have targets in our minds. That's the reason why I have eliminated my 110 permit, which I think I'm going to have to, because it's on an idle status because for other reasons. But I'd like to have opportunity to at least do some prospecting, because these little, my tourist business is good. It's okay. But the mineral potential is far, far greater. And I can't not want to do my tourist business, but I could understand why Amshaw would have a fit with it. So the bottom line is that I want the opportunity to make the decision whether I actually explore and become a real mine or not. So if that's the case, then I'm not opposed to this.
Sure, Dave. These regulations do not prohibit an NOI and a tourist mine.
So through your organization, will there be a mechanism to convert my 110 permit, which I haven't been able to use, to an NOI?
That conversion's not an option under the Hard Rock regulations. Generally, you just have to obtain a new NOI. It's an $86 app. I think it's still $86 application fee.
Well, I'm familiar with that. Okay.
So yeah, you'd have to apply for a new NOI at your location.
And the other concern I have, the reason I haven't dropped my 110 permit, is because I've got part of the stuff we've built under 110 permit that I'm looking that the tourists are actually liking to see. And I'm worried about actually having to eliminate my tourist business because I have to do reclamation. So I'll talk to you other part of your organization about that, but this is what a mess.
Yeah, you can give me a call or send me an email. This is Russ Means, and we can talk about that. There's certain aspects and stuff of your reclamation plan and stuff under your current permit that we could modify and stuff to leave existing structures and do away with the 110. Excuse me,
Okay,
110-1.
You will hear from me. You will hear from me.
You'll hear from him.
Thanks, Dave.
Okay,
Thanks.
thank you.
Hank, you've had your hand up for a while. Go ahead and.
Yeah, if I can remember what I raised my hand for, just to kind of address some of the issues regarding the nuances between the two, and something some of you may be facing. If the markets improve as such, you want to become producing mines, and some of you have alluded to the fact that you have separate mines, separate portals, separate tunnels, maybe even separate air courses, and you may not be affected as tourist mines. But what I see just from the information I have is if you do go to producing mines, and I think Jason and Michael were alluding to this, is it will change the face of your tourist operation. If you're using a tourist portion of the mine, you're going to have to fall under MSHA regulation. We have no control over that. We have no say in that. For instance, if your portals and the structure around your portals isn't MSHA compliant, and I know that is a great selling feature for tours because you have a lot of nostalgia, a lot of history posted around those portals. It may change that. And in cases I can cite like maybe the smuggler or a lot of you operations that have period piece structures around your portals. We can't affect that. We address that in the state rules, but it could change your operations without anything to do with this policy or these regulations. Just food for thought. It's not anything we're imposing on you, but it's something that MSHA might. Just food for thought. That was what I raised my hand for. But thanks for hearing me out.
All right, thank you. All right, so can we move on, or do we feel like we need some more explanation from this? I want to be courteous to your time, but we don't want to cut you off either. So
I think we're kind of whipping a dead horse here now. I can't imagine hearing anything more from anybody. This, I mean, to me, it's pretty cut and dried. If you're a tourist mine, you're non-producing. You're not covered by the federal government. That's pretty clear. I'm a tourist mine. I'm non-producing. But I also heard you say that through my exploration, if I see something, then I don't need to apply for this NOI until I decide to really start exploring. I can do my reclamation, I can do my preservation, I can do my tours, but now if I see something, then I apply. Other than that, I don't need to be doing none of this nonsense. Now, these guys that have dual permits, I understand where they're coming from. They want to keep them. They don't want them taken away from them. And I don't blame them. If I had them, I wouldn't either. And if you guys are covering that base, I don't think there's more to talk about.
Yeah, I think
There is a dimension of evolution. Maybe different times, different places for the different activities. But the idea of evolving through from tourists through prospecting to active mining, if you say that that's not something that, for example, would result in a 110 permit under controlled circumstances, moving into MSHA compliance, you're traveling into territory that basically every commercial mine of any size worldwide, regulated by MSHA or whoever, is doing tours of an active mine on a fairly regular basis, frequently with customers, sometimes like Peabody with the idea of improving local support of the value and the economic contribution to the community and providing jobs and whatever. But those things are going on. You can't say that all of a sudden, because there's some feeling that we want to stop that evolution. That doesn't make any sense. Evolution, yes, maybe increased regulations, maybe the portals need to be, as they're renewed, come to MSHA standard. There probably should be good thought and action given to those ideas, improving the safety, but regulating how far you can go with your property seems to be a step beyond the regulatory challenge that one or two words in this sentence presents to you. So we'd ask you to take further consideration of this with the understanding that somebody, maybe me, maybe not us, maybe the smuggler, maybe not them, but others, some already have copper on the other end of a long tunnel. May evolve in that direction. Just make them comply with the regulation for what they're doing. Maybe separate the when and where for some of these things, but the MSHA doesn't separate the tours from the active mining, because that's what the tours are there to see when they're doing it, be it Peabody or Henderson or Rio Tinto or whoever.
Well, and I think to circle back to what Jason said, if you guys, you or anybody out there can send us, your clarification of this rule for our consideration, we're not throwing anything out, this discussion, this rulemaking is for this purpose. But I feel like we're kind of getting off track to where we're just kind of repeating the same things over and over again, and we're really not making headway. So I feel at this point, we've kind of laid everything out, our expectations. You guys have your own expectations, and that's fine. This is America. You can do that. We ask that you put it in writing and submit it to us, and then we can review it and then, make a educated decision at that point.
I get just one more
Go
thing
ahead,
again, Jeff, it sounds like.
But remember, we're asking you to stay on the health and safety and benefit to the public and benefit to the people who engage in these tours, both the participants and the owners, and not to step beyond that task. You're getting derailed.
Thank you.
For this, it sounds like there is definitely interest in more time to review the rules, consider some of these discussions, hopefully submit some of your comments and ideas in writing to the division. So we've got something in writing to review. I think so let me take a couple steps back. This rulemaking is conducted by the director of DRMS. So Michael Cunningham will be the one that will be kind of overseeing and making final decisions on these regulations. That's the way that the process is set in statute. So this rulemaking does not go before the Mineland Reclamation Board. Based on discussion today, we'll be in touch with Michael and suggest that the hearing on the 19th be continued. What I'm interested in, without kind of losing too much time here, is how much time is reasonable for you all to review these rules and hopefully put together something in writing to submit to the division for not just consideration on this kind of the dual permitting concept, but the other rules that we've not yet had time to get to. As we said at the outset of the hearing, we don't want to continue this just for the sake of continuing it. It needs to be some reasonable continuance of the hearing so we can get back to this, hopefully in advance of the start of the tour season, maybe not. But if we were to suggest to the DRMS director to continue this hearing, what's a reasonable amount of time for you all to review these rules and submit things in writing? 60 days from now, reconvening kind of February, March time period. More time than that, less time than that? I guess folks that have positions on that, please, I'd love to hear.
Again, this is Kent. A couple of thoughts. One is some of these changes are definitely improvements and should be enacted without great cause or concern or delay. This particular one is beyond the scope of responsibility. It's in interpretation, and we've got to figure out a better way of dealing with it than just coming down with something on the industry. This isn't good practice. You're dealing with an industry where the owners of these things only get together once a year. I think it's in April. And they're of all ages and medical conditions, and there's travel and grandkids and school bus full of kids, like mentioned before. All this is going on in all of our lives at the same time. We don't have the time to spend a year like you have on coming up with these ideas.
Ken, how much time do you think it would take for you to review these rules and put together some high-level comments and talking points for the division?
I would suggest that you think in terms of when the affected parties are gathered in April at the normal meeting, where they actually have time to face discuss them, as opposed to just sending them out. And the distribution to was distribution to stakeholders was very, very limited. And to require weeks and weeks advance notice of whether or not you can sign up or speak was a little bit onerous. The distribution was, compared to the actual stakeholders, was really limited.
Well, again, I mean, it was pursuant to the state process for commencing a rulemaking. It was published in the Colorado Register. We made sure that the staff sent it to parties that were most interested and impacted. I agree, it's a bit of an onerous process, but that is the state rulemaking process in Colorado. We're trying to make it as open and transparent as possible, and that's why I think, again, asking for some feedback on how much time is it going to take folks to review these rules now that you have copies of them. We've had some discussion to review them and provide the division with some written feedback.
A thought that really ought to be considered is, when can the group of the owners and operators of these things get together, and there is a schedule for doing that. I think it's April. So out of that could come a consensus as to what should be done.
Well, Ken, let me just give you kind of, let's work backwards here. That April meeting. So we've gotten through Rule 1, Parent 18 so far in an hour and a half. And so if in fact it is in April at the Tourist Mind Workshop, this is going to be, unless there's a consensus within the stakeholder group, when we all get together, unless you guys get together before that April meeting, the April meeting is going to be obviously more than one day. And we're speaking about timing and responsibilities, and I know it may seem different, Ken, but quite frankly, we all have responsibilities. We haven't been working on this for 1 year. We've been doing, we have other tasks, and so just keep that in mind in terms of timing. If we utilize just that one day, then that's all that's going to get accomplished that day, if not more than one day. And so it would be important, and it would be a good recommendation to just focus on which particular rules are of most contention, right? Like this one's
Good
one,
point.
obviously,
Good point.
but there is a lot of this stuff. There's typos. We fixed typos. We fixed language, modernized some stuff. And so those rules, to your point, Ken, are just simply, we're moving on. Those rules are fine. We're modernizing them. No big deal. So I would focus strictly on rules that are most important to the group, to the stakeholder group.
So real quick, if I may, Fred with the smuggler here.
Hey, Fred.
Obviously this rule is probably the biggest contention for everyone. Couple of key points. I think as a team, if we had known that there is a path and an avenue for an NOI and a tourist mine to coexist, that probably would have settled a lot of people's anxieties. Also knowing that the dual use permit mines that are currently in place were going to be grandfathered into this, into these rules. I think for the other people who do not have dual use permits, they are faced with a situation where the owners of those mines, if put in the position of being a producing mine versus a tourist mine, they're probably going to go with the production for financial reasons. So that's a lot of, I think, people's concerns are that we're going to lose a lot of the history with the tourist mines if put into that position. So I think having maybe those 2 points put into these rules where there is an avenue for an NOI and tourist mine to exist, as well as the 4 mines that are currently permitted, would be helpful. The other thing I just wanted to mention is that MSHA is very aware of the Smuggler mine, both doing tours and being a production mine. They have participated in on-site training. They have seen the facility. It's been a while since they've been up there, but it is something that we have done for many years. I believe I just looked at our permit, dates back to 95. So that's 30 years of coexisting. And there are stipulations in there to where we are not actively mining and doing tours at the same time. And that has worked flawlessly for 30 years. And I'm sure there's paths and avenues for other mines to have that opportunity in the future. We just need to work through it.
Agreed.
Brad,
Thanks for
very
the
well,
comments. I
Brad,
appreciate that.
very well said.
I was
Thank you.
gonna ask Fred, do you guys currently have a 110 permit with DRMS? Is that the dual permit you hold?
Yes.
Yes, okay.
And I think we could probably, if it's kind of just limited to this one rule and understanding DRMS wants to keep this ball rolling and not wait till April. I'm not going to set a time period for everybody else, but I would think within another maybe month, if we wanted to focus on comments on this rules, we could maybe put some things specific in writing and have them back to you. But again, I don't want to speak for everyone on this call.
Yeah, folks, one thing to remember is if these rules go into effect on the 20th of April and I'm trying to open my tour on the 10th of May, it's going to take some time to go to get all my training set up and all the other things that are included in all of these various regulations. So we really can't just be pushing this thing off unless you're going to hold off a whole nother year, because it's going to take time for everybody to get up to speed with the signage, and there could be many other things that they don't look like a lot, but when you add them all together, it takes time to develop these safety programs and training and forms and whatnot. So another 30, maybe 60 days for additional comment, seems reasonable, but putting it off till April, that's I don't think that's reasonable.
Yeah, but we certainly appreciate that. And that was kind of the timing, just to give you a little background on the timing with this. And the reason we say we wanted to get these rules promulgated before the tourist mine season, because that gives us an entire season to work with you guys on. We're absolutely not going to promulgate rules, they go final, and then we're enforcing the rules on day 2. What we felt like is we can promulgate the rules now. That gives the tourist mine operators an entire year that we can work with you. Well, here's what the rule says. What can we do? And we're not going to go out there and go, hey, where's your signage? Where's this? Where's that? We've never done that with any mine. We're going to work with you, and that gives us an opportunity for, we have a whole tourist mine season to see how these things work, to work with you on in getting them all the rules enacted. And so that was kind of the reason for the timing, doing it at the end of this year rather than in the middle of a tourist season, and when mines may be closed for the winter, those kind of things. And so that was kind of the thought of our timing.
I don't like the thought of doing it on the fly. I would much prefer we discuss and talk about before we implement. You already nailed my important issue. It just seems impossible to get this done in the original time frame. We need to just come up with a more reasonable time frame. If I could make a suggestion, I'd like to say 1 to 3 months seems being involved with a few legal matters. That seems to be the dogma for when all the lawyers can figure their nonsense out. So I think somewhere in between that time frame, it'd give a reasonable amount of time for both everybody to come up and submit written comment. And not only that, I would like to propose a Zoom meeting where we don't have to waste your guys' time. We've got 17 or so individuals here that are all directly concerned. I think once the word of this meeting gets out, there will be the 2 or 3 others that were like, oh, we had no idea. Give us a chance to go over some of this, so we're not just fielding 19 individual responses here each time. We can all kind of get on the same page and talk about the ones that truly have merit for discussion, and the other ones that are just purely grammatical and update that nobody's going to reasonably disagree with. But ultimately, I think, and I hope anyways, that I'm hearing from you the same thing that my concern is trying to get this all done inside of the time period originally given is just not realistic. Not sure what a reasonable time frame is, but I would like to see it spaced out a little bit, because frankly, we haven't even gotten to the ones that are of major importance to me. So I think 2 days might be an understatement if we hold all this until April.
Thanks
What
for
is
that.
the possibility of scheduling right now? Well, I've got all these people a date even, just 1 month from today, if we even just push it out to December, getting together again so we could go over this with a little bit more clarity. And would you think it would be useful for all of us to meet aside without taking a giant meeting away from the state's resources, or should we just do this as we're doing it now, get everybody here and just keep logging through them?
I think we're fine with really either option. I think we'll certainly, this has been a helpful meeting. I think there's value in us hearing from all of you and having you identify the draft regs that didn't quite hit the mark, that raised some concern. If there is an ability for, folks on this call to get together outside of DRMS folks be involved in trying to coordinate on issues, that'd be super helpful as well. You'd streamline the issues, kind of probably present concerns to the division in a kind of more efficient way. If you can pull such a meeting together in December, that'd be fantastic. If not, I think the division, we could set another virtual stakeholder meeting like this at some point in December, just check in and see where things are at. Maybe by that time, there might be some written comments, not just on the dual permitting issue, but some of the other issues, communications, the fire issues are the ones I'm anticipating. There'll be some questions on that. I think there's value in any time we can get together and discuss things, and you guys can identify comments, concerns, or things that are fine, have no concerns, that we can kind of set aside to not continue to discuss things that aren't a concern. Scheduling in December can be difficult, but I think it's worth trying.
Our timing is terrible.
Yep. So at this point, and I can't remember if we set till 11 or 12. I don't know how much longer. Till noon. Okay. I mean, I think we can still move through some of these things and maybe just put a pin in the dual permitting issue and see if we can't tackle some of the other issues with the time we've got reserved here, if folks are willing to stick around for a little bit longer.
Hey, it's Chris from the Smuggler. I'm back on top for a few minutes before going underground again. But Chris, I agree with you. I think I'm totally for it, that without wasting state time on a big Zoom meeting, that we operators get together and have a Zoom meeting, go over this so that the next time we meet with the state, we have a concise, forward-moving plan to write up and present. That way it doesn't waste everybody's time. Like you said, an hour and a half on this first one, and that's quite a bit. I didn't imagine I'd come out to this. So anyways, I'm on board with you. So we want to put it together. Let's get it put together.
Just for fun, let's look at the calendar. Or I'm sorry, I don't want to do this now in your time. We can also shoot an email. Here's a question, and I won't waste your time beyond this. I sent an email out when they sent the original request. If you received that email, I know Chris did. We spoke, Fred too, I think, a few others here. Kent, great if you received it. If there's anyone on here that did not receive it, I'm happy to try to coordinate this. Can you please take a note of my email so that you can get a hold of me and that I can start working on it? My email is Chris, CHRIS, at HeidiGoldmine.com, spelled HIDEE, goldmine.com. Get us all on the same page email wise, and then we can come up with a date to set a Zoom meeting here in 2 to 4 weeks. Does that seem okay with everybody?
Yeah, would you be able to put that in the chat?
Yeah, possibly.
We would very much like that.
Assuming it involves, yeah, it's actually pretty easy. All right, I should have sent that out to everybody.
Got it.
Excellent.
Chris, thanks for that, and thanks for helping coordinate the group. Again, reach out to you know, us as well. If you've got questions that you want, you know, an answer on before you meet or those kind of things.
Yeah, and again, having you guys are going a lot quicker than I am on responses, and I greatly appreciate it. So we'll continue to do that. And I think I have most of your key players' emails through that as well. So probably as good as anybody to facilitate it, if that's all right.
Hank, this is Ken again. Could you send out a list of who you originally sent the distribution to, who you considered stakeholders? Because there were quite a number of people in several dimensions that felt themselves as stakeholders, but didn't find out about this until quite late, fed by the rumor mill.
I bet you $10, my uncle's still trying to figure out how to get onto this thing. So there's other issues as well with some of our guys.
So I don't know as far as that would be a discussion I'd have to have with Jeff as far as giving out personal information and stuff like that. I don't know whether I can give you a list of everybody we sent to. We have all the tourist minds in the email that we have for them that Kim sends out every year for the tourist mind workshop, and that each mine is to send in their preseason report. So we feel we had a pretty up-to-date list as far as emails, you know, but as far as I don't know if I can.
We can share business emails. We can't share personal emails, and that person gives us permission to do so. So it gets a little tricky when.
What I'm suggesting is that the official contact for many of the tourist mines is identified quite accurately, but the stakeholders go beyond that. There are quite a list of stakeholders that are dimensions beyond.
And you're just asking for a list of names. You're not asking for any personal information, correct?
Well, I mean, even at that, I don't know. Can we give out names?
We can share names. Yeah, we just can't.
Okay.
Phone numbers, emails, addresses, those kinds of things.
Just PII.
Yeah, we can share names.
Yeah, but that'd be helpful right there, because we'd know which
one.
ones didn't get the message. We can kind of track down. Most of us know each other. I mean, this isn't we should be able to do this on our side, as long as we just be nice not to have to start it going for everybody. If you could give us a clue on it, like here's a question. Could you tell us who did you contact that's not on right now, so that my email could catch them up with it? I don't even ask for their contact information. I don't know. Is that information we could get?
Well, I mean, yeah. We have she has a list of everybody that we've sent it to. 13 names.
And then we got what? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Don't we have 13 people? Is this everybody?
You had 26 people on your email that you sent out, Chris.
I used that from my records. I just went back and tried to find every single mine guy I could find that I've yacked at over the last 20 years. So that was where that list was derived from. Hopefully it tagged most of us.
Yeah, whatever list you compile that you think is kind of a good representative of the stakeholders, if you wouldn't mind sharing that with us too, so we can, again, pull in as many people as we can, get as many people's thoughts as we can going forward here.
And not to be out of bounds here, but is anyone representing the Molly Kathleen at this meeting? Say now or forever hold. There's no Molly Kathleen representation here? Because that might be important too. Shouldn't they be involved to some degree? I mean, I know they got some legal issues going on, but maybe at least.
I know, but I'm talking to their employees recently. I think they're pulling out of the tour business altogether. They're done, based on what my friends have told me.
Well, that's that's a whole nother pile of soup. All right.
Well, before we jump back into some of the red lines, just kind of tying up some administrative loose ends. Because the hearing was noticed for the 19th, likely what I'm gonna suggest that Michael Cunningham, the DRMS director, does is convene that hearing, find a date to continue it to at some point in the future. That way we don't have to go back through the re-notification process through the Secretary of State. It's a somewhat tedious process to do that. It's far easier just to open the hearing, continue it on the record, and then close the hearing. That kind of preserves our process with the Secretary of State. Probably after this meeting, we'll look at whatever future date we might continue it to. Just know that it's not going to be the set in stone rulemaking hearing. It's just something to kind of keep the process on the tracks as we're going forward here. So you all are still welcome to join on the 19th, just to follow the conversation, but that's likely what will happen on the 19th.
Do we get another invite like we did for this one, or?
Yes.
Excellent. Thanks.
All right. Well, moving on. All right, so Rule 2, there were just a few changes here. Let me get it up on my little sheet here. Obviously, there was some spelling and different things in number 1, but number 2 had the significant change that I thought we want to make sure we cover. It says daily inspection of tourist mine by a competent person designated by the tourist mine owner operator is required. Any hazards that may adversely affect the safety and the health of all persons shall be noted and corrected, and corrective action taken. A record of each inspection shall be completed, dated, and signed no later than in the shift or business day for the exam was conducted, and shall be maintained for a period of 3 years. Okay, so that's basically what we added on there. Is it's got to be done by the end of the shift. Clarify that, and then to maintain them records for 3 years. All right, and then of course down here, if you go down here, the only thing we changed in A was proper ventilation and oxygen levels. We just added the oxygen level requirements. And then moving down, we added G, H, and I, which is mind maps, the extent of the tour route, escape route, documentation of annual safety training for employees, and daily examination records. Okay, so any issues or concerns with that one? All right.
Is that essentially we can just continue using the same daily examination books you've been giving us? That nails that. Correct. Yeah. It's your requirement to maintain them for 3 years, and it's a requirement to make sure they're filled out by the end of the shift. Yep. And then the other few things that we added on there, the G, H, and I, and J, which was fire suppression equipment, and approval emergency and evacuation procedures. So those were just added. All right. For Rule 2, number 4, this had very little. It's more about the maintaining of the records. And then at the very bottom of that number 4, you see where it says training records must be made available upon request in written or digital format to MSTP supervisor or their representative. Okay, so we'll take it either or. No self-guided tours. This is another change. We took out the 50-foot long, blah, blah, blah. Now we just approved by, unless approved by MSTP supervisor or their representative, a formal written request must be submitted to MSTP for review and approval. Okay, I don't think we have any self-guided tours out there right now, but that would change that a little bit. And then for 10B, let me see where we get here. The names of designated person, we took out the owners, and then it's the designated person
the person designated by the tourist mine owner operator as a tourist mine representative. Okay, so we see the need that some mines may be owned by a certain individual or group, and it, you know, the designated responsible person is somebody else, and then we really want to capture the responsible person for this. Okay.
Brandon,
Yes, sir.
wasn't there a change made on number 9?
Number 9.
All displays must be located in an area that is free from any hazardous conditions so that the health and safety of any employee will not be jeopardized if they are required to maintain the display.
Just rewording.
Yeah, it was just a little bit of rewording. It didn't really change the meaning of it.
Is it realistically possible? Maybe this was already in here, but maybe I'm making a mountain out of a molehill here, but it, you know, like say like on mine, I guess this is where it jumped out at me. You're looking in there and you go to the crosscut out there right at the very beginning of the mine. That's all blocked off and you can't get there. It's physically impossible to get there, but you can sure see it. At what point is it a display? And I mean, at what point can you just say that the whole mine is a hazardous condition? So how can you reasonably expect all displays not to be located free from any hazardous conditions?
Well, let me read to you what was previously has been in place when these were originally developed. It read this way: all displays must be located in an area that is free from any hazardous conditions, so that any employee will not be jeopardized if he or she is required to maintain the display. All we did was change it from that to this. All displays must be located in an area that is free of any hazardous conditions so that the health and safety of any employee will not be jeopardized if they are required to maintain the display. It literally, it was a very minor change. It didn't change really the meaning of it, just made it sound a little more.
Yeah, I probably would argue this longer in 2003, but we've been living with it for a long time. So, okay.
All right.
Hey, and I apologize, guys. I have to get on to another Zoom call. So I will listen to the recording for the rest of the meeting and follow up with you guys on getting notes over to you, Chris.
Thank you, Fred. Good to see you.
Fred.
Thanks for everybody's time.
All right, and then we removed 10H. It says, if the tourist mine produces a product, an explanation of how production interfaces with the tourist mine operations.
And that's basically one of the ones we've buttoned for further comment.
Exactly.
Yeah.
So
Okay.
Table that one with the other
table that.
finishing issue.
Okay, and then number 3, the only change we had in Rule 3 is we removed any prior arrangements with MSTP supervisor or his or her representative will not be valid after the promulgation of these rules, which would have been prior to the promulgation of the last set of rules. So it's really, it's not applicable at this point. Okay. Any issues with that? All right. Okay. Rule 4, couple spelling changes, formatting, nothing with any meaning. So Rule 4, Rule 5, this one could affect maybe an operator or two. Air in all active workings in all other areas of the tourist mine where people are required to work or travel shall contain at least 19.5% volume oxygen to ensure real-time 19.5 volume percent oxygen is maintained. A test will be taken with a calibrated electronic oxygen meter. In addition to the electronic oxygen meter, a chemical analysis may be used as backup measure devices. We removed the flame safety lamp. I don't know if anybody still utilizes a flame safety lamp. And we just added the chemical analysis. And then the other change that could affect you is if you don't have a meter that gives you real-time readings, if it's just an oxygen badge that just reads between 19.5 to 23% or whatever the span range is on that. All right.
That's
Yeah,
okay to
yeah.
have that, you said, if you've got a range one?
I'm
Or does
sorry.
it have to, I'm sorry, I may have just missed, but if you have a range one that just shows oxygen okay, and it's calibrated 19.5 plus, is that sufficient, or do you have to know the actual percentage of oxygen in the mine?
When we set this up, we were anticipating knowing the percentage. I mean, this is where you come to the table and say, well, you know, here's my justification of why we feel this is just. We won't discard anything, but as that's how we are envisioning it. Is yeah, you know, you're within a range, but that, I mean, that's all you know. You don't know what the actual oxygen is.
And that's okay though, right? As long as you know of the minimum safety.
Chris, in terms of the actual readings, that's what we want to see in your examination records. If
You
you're
want an actual
utilizing an
percentage.
oxygen monitor or a gas badge, as we call it, that may be something where you might be required to have everyone that goes in the mine wear that while they're in the mine, because it doesn't give a real-time reading. It just gives you a warning.
Yeah. Well, I mean, effectively, it's telling you 19.5 plus, which is
Effectively it is,
Yeah.
but do you wear it all the time? Do your tourists wear it all the time?
no.
So
Nor
how
is
do
there
you
any
know
need in my mind.
what the actual, I mean, if it's 19.5 at some point, it may get lower than that, and you have no way without an alarm of knowing what it is.
So per regulation though, would that be okay if I did my morning check with just the cheapo one, quite frankly, that said, hey, your oxygen is above 19.5. Could I put that above 9.5 per or do I need to spend a little extra money and get one of the ones that says the oxygen here is 20.8, which it generally is?
Yeah, because the problem with just the gas badge or the oxygen badge that we were saying, it doesn't give you that real time reading. So you know it's within that span of 19.5 to, I can't remember if it's 23, 23.5. I can't remember what the high.
20.3.
20.3.
Yeah.
23, you mean, Hank?
23, it has to be,
yeah. Yeah. So we obviously it's giving you that range or within that range, but like to Hank's point and to our point is if it's at that 19.5, you're more apt to be a little leery is why it's at 19.55 or whatever.
Oh, no. I just to be clear though, I mean, like, which one do you, I mean, I mean, if all you need to do is prove that it's over 19.5, isn't that enough? Or are you going to require that we have the meter that shows the exact percentage?
I would prefer you have a meter that shows the percentage. Otherwise, we may, you might petition for modification to use your meters, but it might require you to have multiple meters so that we know that
it's just a money issue. Those ones are slightly more expensive. It's not that big of a deal. I'm just curious if that's an actual requirement or a preference.
To put a pin in your point, if this goes into effect, yes, you would be required to have one that gave you real-time reading. That's where to ensure real time. That'd be the only way you could do real time, right? Otherwise, you would just have a span of.
Well, I mean, they're both giving you a real time reading. I mean, it's just that one is actually giving you the reading itself. The other is telling you the real time reading states you're in a safe environment. It's
I
just
disagree. The gas badge does not give you a real time reading. It does not display what the actual gas is. It just tells you it's within a range.
Okay, that's fine. All right, mountain out of a molehill.
All right.
Yeah, at the old 100, Chris, we're getting meters that are calibrated, come with paperwork, give out real-time data to 1 decimal point. They're $150.
Yeah, it's just more of a nod. I remember when we first started that $150 was, and of course, back then it was like $340 to get a decent one. So we ended up getting
Yeah.
onto eBay and just getting the cheaper ones. And, it's just kind of those little money savers that really helped when we didn't have the budget. And, budget's kind of improved enough to that it's not a major concern for us, but I'm kind of thinking more of the guys that are starting up and getting going and don't have the pockets to have all of that safety equipment and are just trying to get by with what they really need to be safe.
Yeah.
Man out of a molehill, maybe just kind of a nod to where I came from. It's expensive.
I do have a technical question on the chemical analysis method. Are you referring to like the Draeger tubes, the little glass tubes that you
Yeah,
break
I bet.
open? And... Yes, that's a perfect example. Yes.
Yeah.
Yeah. Okay.
So, well, like I said, but that's in addition to. So,
It's not a
an
requirement.
either or. It's in addition to, if you wish. In addition to.
They're just nice because they don't require calibration. They don't, if you know how to use them, it takes a little bit longer, but they're just as accurate, if not more so.
Yeah, and you need to have a backup because you drop a meter, it breaks, it falls in the ditch, then you don't have a meter. We typically actually buy 2 meters to make sure we have a backup, but this chemical Draeger system might be good for backup.
Yeah, okay. Is everybody good with that? We're moving on. Okay. So the fire prevention and control, this is where it's going to look like we've really got the red ink going on. A lot of this, these first 3 were added, but a lot of these were standards that were pulled out of the CFR to not reference the CFR and to bring them into our own standards so we can regulate them since we're not regulated under MSHA. So, I mean, that's what most of this is, but this one here, these were added when welding, cutting, soldering, thawing, or bending with an electric arc or an open flame where an electronic conductive extinguishing agent could create an electrical hazard. A multi-drive chemical fire extinguisher or other extinguisher with at least 2A 10 BC rating shall be at the work site when welding, cutting, soldering, thawing or bending with an open flame in an area where no electrical hazard exists. A multi-purpose dry chemical fire extinguisher or equivalent fire extinguishing equipment for the prevention of a hazard class shall be at the work site. And then it talks about the use of the halogen fire extinguishers in the appropriate type. Okay, so that's just in addition to the number 1 says fire shall be limited underground except for open flames, torches where lit. Torches shall be accompanied by the necessary fire control equipment. So it helped kind of define what we see as suitable firefighting equipment. Does anybody have any concerns with that? Okay. Then we're going to move on to 4. I get 4 is the next one. It says fire equipment shall be inspected according to the following schedule. The tourist mine owner or operator shall maintain and provide documentation of dates of the inspection and when required testing was conducted. Okay, so we took it. I don't know. I can't remember if this had any standard. I don't think it does because it would have been crossed out. It's just basically kind of defining that as to it is the owner operator's responsibility to make sure they are inspected and tested accordingly.
I think this is just kind of a general best practices that you see some of these kind of additions throughout the regs of just more express language on maintaining documentation of inspections and testing and all the other stuff, just that when the divisions out there, they've got access to these records.
Okay, and then on the bottom of number 6, we added this standard does not apply to pneumatic or compressed air powered mobile equipment that does not pose a fire hazard. It's the requirement for a fire extinguisher. So
Brandon, I have a question on this one.
Okay.
Are we, obviously, we're talking about fire extinguishers on locomotives, on trammers. What about the man trip cars? Do they require a fire extinguisher?
Is there a component that would create a fire hazard?
Okay. Well, they probably wouldn't be a fire hazard. The car.
The car itself, no, the engine, yes. Okay.
Right. Okay. Got it.
That's the way I would see that, but yeah, I mean.
Yeah. Very good.
If it's battery powered or diesel, it should have a fire extinguisher on it.
Oh yeah. Yeah.
All right. And then of course, this one we've changed. I think that's one we'll probably get some feedback on. Number 8, it says storage of fuels and combustible liquids for underground and surface must comply with 30 CFR. All we did there is take out the requirements and we added basically what was already there. We just took it out of the 30 CFR standards and put it in our own standards. All right. And this will talk about combustible liquor stored underground, including oil and grease, shall be stored in non-glass containers or storage tanks. That containers or storage tanks shall be capable of withstanding working pressures, maintaining manner that prevents leakage, locate underground areas free of combustible material, separated from explosives or blasting agents, and then so that's all. I mean, I can read the whole thing if you guys want. I mean, it's pretty well summarized exactly what is stated in the 30 CFR, which we were following anyway. It's just we pulled it from one and put it in our own document, so it'll never change if 57.4462 changes for some unknown reason. Okay. Any questions? Yeah. 9, underground storage tanks shall be vented or otherwise constructed to prevent development of pressure or vacuum as a result of, sorry, I can't read up that. Is it filing? Filing, emptying, or atmosphere.
Filling. It should be filling.
Filling. Oh, sorry. Got to adjust my bifocals here. Temperature changes. Vents for storage of class 2, class 3A liquids shall be isolated or separated from ignition sources. And then 10 goes down to at underground permanent storage areas for combustible liquids shall be provided for containment or removal of the containment of the large storage tank in the event of the tank rupture. All underground piping, valves, and fittings shall be capable of withstanding working pressures. Okay, like I said, this is all kind of this might have been added.
I think sections 10 through 14
were all added.
Added in. That's not CFR language, but those are either current best practices or standards or what you all currently expect to look for.
I think that a lot of this came from the active mines, correct, Jason?
Well, I mean, yeah, most of it, quite honestly, came out of the CFR.
The CFR
for like underground piping, all that stuff. We wanted to memorialize it under our rules, the Colorado rules. But yeah, there's some discussion in here that that we put in, certainly, but it is we stuck to what was already in there, and in this section it was certainly associated with the CFR, and it would mention, Jeff, you can correct me wrong if you have the regs there, but it says might be a line in there that just mentions the CFR number. So we had to go in because we don't want to just mention a number. We had to go in and see what that regulation, that CFR regulation was, and then break it down to fit into our rulemaking.
Yeah,
that's kind of what it is. So it doesn't change. We're just memorializing it in a way that it's not under the CFR.
So I mean,
those are the changes in paragraphs 9 through 14 is to be consistent with the Federal language.
Yeah, it's consistent with the federal language without mentioning the federal language because we don't regulate the federal law, so.
Right. All right. Any concerns or issues with that? I mean, we're already doing it. It's just now we're incorporating into our rules versus referencing another set of standards. Okay. 15, some changes we had here, and I apologize. I don't know why this did it, but you can see where that little C, big C went in. It decided it's going to go little S, big S. It decided it was going to go do all that for me last night. So I apologize for that. I don't know why I did that. But anyway, it says small quantities of flammable liquids drawn from surface areas storage shall be kept in safety cans, shall be stored in designated flame liquid storage areas when not in use. Okay, so a little bit of change to the language there. All new surface buildings or other similar structures constructed within 100 feet of tourist mines, tourist mine used for intake air or within 100 feet of the mine opening that are designated escapeways and in an exhaust air shall be constructed, and it talks about the requirements for the fire prevention. Constructed non-combustible material, constructed to meet fire resistance ratings, provide with an automatic fire suppression system, or covered by all combustible interior and exterior structure surfaces with non-combustible material or limited combustible material, such as 5/8 inch type X gypsum wallboard. Okay.
Yeah, same situation with rules, parent 16 and 17.
Yeah.
Those are just mimicking that 30 CFR that we wanted to spell out rather than just referencing a federal regulation.
Yeah, I have a question on
made a pretty
17.
Significant change.
Okay.
Yeah, am I someone else jumping in on that one? Go
Well,
ahead.
yeah, 17, are we including lagging behind steel sets
Okay.
needing to be fire retardant?
Oh, why did you take the new out? Was that a typo for number 17?
No, so 17, all we did was take the standard that
That
is
MSHA
already
uses,
But we
which is
took the new out.
ridiculous
You
to
see that,
apply to
Brandon?
us.
To his point, we took
any
the
new.
MSHA standard
Oh,
with new mine entrance. We took out new.
yeah, and I think we
can certainly include that. 'Cause
yeah,
that's what-
I don't think that was supposed to be taken out. I do believe it was supposed to be any new, because I remember talking about
Yeah.
that. Yeah.
I thought that might be a typo because you'd
Yeah.
wipe out the Phoenix, you'd wipe out the Heidi, you'd wipe
No.
you'd wipe out
Yeah, you're
almost
right,
all of
Chris.
us right there.
Yeah, you're right, Chris. That,
Yeah.
yeah, we'll add that, the term new mine entrance back into that one.
Yeah, we
Okay.
apologize because it was on 16.
Yeah, we discussed it. We just didn't get it changed in 17. We changed it in 16, forgot to change 17.
16 or anyway,
That's
yeah,
better.
that's on us. We'll get that changed.
Thank you.
Okay. Bill 6. All right. Compressed air cylinders. The only thing we added here is compressed gas cylinders shall be secured to prevent falling, tipping, or coming into contact with tourists. I mean,
I hate to say this, but compressed gas cylinders, this has been a tickle point in MSHA. I mean, you're talking cans of WD-40. They consider that a compressed gas cylinder.
And all you have to do to secure them is put them in a box.
Yeah.
That's fine. That's enough to meet the whole strapped provision.
Yeah, it's a little different than a 300-pound acetylene or compressed oxygen cylinder, but yeah,
it's secured in a box.
It's secured where it's not going to fall or be a tripping hazard.
All right. Rule 7, just a little bit of formatting issues. No major changes there. Emergency and evacuation procedures. We added, incorporated with the preseason report and submitted. for, to the MST supervisor for their approval by April 1st of each year. That was just a small change there. Shouldn't change anything that you guys already do by submitting your preseason report. A map or a diagram of the tourist mine will be posted and maintained at or near the tourist mine entrance. The map, is that right? Did we take
No,
that out?
that's not a take out. We added.
I was gonna say, I don't know why that's taken out. I thought
We
that was added.
added and at the end.
And at the end of the tour areas underground, furthest point of tour travel. So basically at the end of your tour, you just got to post another map. Okay. The map and or diagram will show the normal direction of principal airflow, location of escape routes, location of existing telephones, and location of refuge chambers if they exist. Okay.
In regards to airflow,
Uh-huh.
we're bi-directional barometric airflow. What direction would that be?
Summer incast or outcast and winter incast is all you
Yeah,
need to say.
it breathes though. I mean, like I say, it goes both in and out. Almost
Well, I mean,
12 hour to 12 hour.
yeah, I mean, truthfully, we didn't add or take that one out. That was a pre-existing.
Chris, what are you doing now to comply with this?
It's not on our map at the moment. I didn't even realize that airflow needed to be on the diagram. I mean, I've got multiple maps posted throughout the mine, but I will admit at the current time, they don't have the airflow on them.
Well, if you
Maybe
just
that's
wanted to
something
put this on, I think it's relevant on an escapeway map. I don't think it's, in terms of what you provide for your permitting, but on an escapeway map, maybe just in 2 maps with different times of day or different seasons. I don't know.
Right, just address it by saying it's bi-directional. I mean, I suppose if that meets the letter of the law, that would be all right with me, but I don't know. I don't know. I guess I'm just a little
would you
confused
mind
by it. I
sending
know it
us an
exists. I know
explanation
it's
of
old news, but I'm a little
how
confused.
you feel it should be? Like I said, we will review that. I mean, that may be something that we feel that it may not fit the situation.
See, looking at maybe Jack's situation up at the Last Chance, most of his tours happen during the daytime when the air flows one way and overnight it reverses. So maybe if it's an escapeway map, just post something that would pertain to tours, if that makes sense.
If I can ask a non-technical lawyer question here, who is this map geared towards? Is it tourists that are in the mine? And if that's the case, I guess we want to make sure that the map don't just confuse them more.
Mm-hmm. I mean, essentially it's for the employees and for the tourists, right?
Yeah. Folks who don't know. So, okay.
Yeah.
I think it's for emergency personnel too.
Yeah.
Yeah. Okay. All right.
So, I mean,
yeah, then it is
to Jeff's point, maybe it's an unnecessary evil. I mean, although being a mine rescue personnel like Hank and Tom, direction of air travel is important.
Yeah,
right.
And for that case, then yeah, maybe if it's not geared towards the tourists themselves who won't have any concept of bidirectional airflow, if it's for the safety rescue folks, then it is helpful information that. So like Chris, sounds like in your case where it's not just a straightforward response, I'd work with the division on what makes sense to put on the maps and then implement that at some point in the future.
Yeah, we'll work that out. All right. So number 4, we added such training shall be documented and maintained for a period of 3 years. Such records shall be made available for inspection by MSTP supervisor or their representative. Basically, that's just kind of bringing back, what we said earlier is, provide the training and upon our request, take it in writing or digital format. And then for number 5, we just change it from 24 hours to 30 minutes. In the event of an emergency, just to, allow us to, provide assistance if needed or if available. So,
And
any
this,
questions
I
on
think,
that?
also is important in relation to what happened in the Molly Kathleen. There are a lot of entities out there that, had no jurisdiction, and the ones that did were not contacted. So I think this is kind of important rather than waiting a full 24 hours to notify the state.
All right. Then number 9, this was added, and this is right out of the MSHA standards: defects on safety self-propelled mobile equipment affecting safety, which are not corrected immediately, shall be reported to and recorded by the tourist mine owner operator. The record shall be kept at the mine from the date of the defect. Defects are recorded until the defects are corrected as per the manufacturer's recommendation. Such records shall be made available for inspection by MSTP supervisor or their representative. Okay, it just memorializes that that number 2. Okay.
Just a question on that one, Brendan. I don't see a time frame. Is there a time where they no longer have to keep those records? How long do they,
Well, if I read into it, you should check until the they said the record shall be kept at the mine from the date of the defects are recorded until the defects are corrected. So once the defect is corrected, you could discard that.
Okay, that's the way I read it, but
Yeah.
yeah.
So here, let me look at mine. I don't know why I have. Oh, this was all persons. This part was added. All persons who are exposed to contaminants of known airborne contaminants are expressed level. I don't think that's right.
We didn't, number 6, we didn't change. We just took out the reference.
I'm looking at number 1. Rule 10, number 1.
Oh. Rule 10, number 1, all we added was at the end of that, all we added was all first aid materials shall be present and up to date. That's all we added at the end of number 1.
Yeah, yeah, and so I don't know where that came in. I apologize. But for number 1, like Jason said, all first aid materials shall be present and up to date. That's the only change to number 1. Number 6, we took away acceptable levels of contaminants are those set by MSHA in Title 30. There we go. We just pulled 30 out of it. Okay. And then number 7, we changed just some wording, and we also require a gas detector. So employees required to work in an isolated area of the mine away from the tour route must carry an approved self-rescue device, cap lamp, and gas detector. Okay, so that was the only change there. Any concerns?
Just a minor one. I know in the MSHA regs, you don't necessarily have to carry the mine safety the self-rescue device with you. It just needs to be accessible.
It's got to be within a certain period.
Yeah, I forget what it is, like 10 feet or something relatively reasonable, but could we mirror that so that we don't have to lug those things around all the time?
Certainly, if you have caches of self-rescuers in the mine, that's acceptable. But in isolated areas, yeah, I think you're limited to something like 25 feet.
Yeah, but you don't have to carry it with you all the time. You can, whereas here it says you must.
So you just wanted to read where maintain it within a certain distance.
Yeah, just to mirror MSHA's. I think they came to this. It's just it's the difference between having it next to you and having it on your belt could be a giant issue when it really shouldn't be, frankly.
Okay. Yeah, we can look at that. That's
Yeah,
not a problem.
it's a minor point.
Yeah, well, that's what we're here for. Rule 11, this had some changes
Excuse me,
in it.
Brandon. Pardon
Yes,
me.
sir.
Could we go back to Rule 9, item number 8, shelter holes?
Rule 9, item 8. Okay, I didn't put that one on there. We sure can.
We didn't revise that one.
Oh, well, yeah, you didn't change it. I just noticed that on item 8, shelter holes, on number A, it's providing clearance of 30 inches. And then when it says B, the shelter hole shall provide minimum 40-inch clearance. It probably should be 30. I don't know why you would say you have to have 30-inch clearance and then say you have to have 40-inch clearance. Because we do have shelter holes in the main haulage.
Let's see, where continuous clearance of at least 30 inches cannot be maintained from the further projection of the moving equipment, at least 4 feet wide mark, providing minimum 40 inches clearance from the further projection equipment. Yes, we can look at that and see what the standard is. I don't know what the standard is, so I don't want to say a number.
Yeah, and I don't know what the actual clearance would be on our shelter holes. So we've never measured the distance. Obviously, they clear the train fine. I mean, this can be addressed at the inspection too. And then if it's, if we only have, 30 inches and the rule says 40, we get a waiver or something. But maybe just take a look at that. It just struck me that logically they ought to be, if 30 inches is safe, then it ought to be 30 inches.
Okay.
Separ FC2 also uses the 40-inch clearance threshold.
Okay. So yeah, we'll take a look at that.
Okay.
Thank you for bringing that up. All right. Let me see where we left off. 11?
Yeah.
All right. So for 11, get back here so I can read it. A communication system must be installed and maintained in a functional condition for the purpose of effective way of communication between surface and underground operations. Add a little bit of wording there, and then we also added training shall be provided to all tourists on proper usage of communication systems in the event of an emergency. Okay, so a quick tutorial of, all right, this is the type of communication system in the event. This is how we utilize it. Okay, so a written plan.
Would it be possible to just have signage by the telephone rather than having to quote unquote train all the tourists who entered the mine in proper use?
As long as it communicates the important information, I don't necessarily see an issue with that. I mean, I go to Part 46 sites that's their task training is a sign you read, right? So, and unless we hang up and they beat me with a rubber hammer, I don't think that's unacceptable. But I'd have to clarify it. But I think that would work.
Yeah, I'm kind of in the same pitch. When I see training, I think of that task training, it needs to be signed off, approved. You know how to use this piece of equipment, and the thought of doing that for every single customer who comes through the mine, I don't know if that's even it sure take a long time.
I still think that there needs to be a training piece to this, because you could have signs, but if the tour route or the tourists are unaware of these signs, I mean, all you have to do is say, we have phones strategically placed throughout the mine, and we have signage on how to utilize it. But I still think there needs to be a training component to it. for the general public's sake, so they understand that that's how they communicate to the surface.
And that could simply be part of the tour. You just stop at a phone station and say, if something happens to me, something bad happens in the mine, here's the phone. These are instructions on how to use it right here. You just point it out.
The other thing I
You
look
don't
at,
have to do that. Go ahead, Tom.
the other thing I'm looking at is the amount of people that come on these tours that can actually understand the concept behind it, and can they actually read it? Are they, is it bilingual? I mean, those are the things you got to take into consideration of people actually reading the instructions. Is, do they understand what they mean? As those are the things that we're talking about here, is training people on knowing exactly how to use it. It doesn't take that long. Just like Hank said, is you stop at one of them and say, this is how this phone system works. That way, in the event that something happens to the tour guide, somebody knows how to use and operate the communication device.
Yeah, I fully agree that you got to do some training. The loudmouth phones we have, you got to pull the pager level over. It has to go over all the way. You got to train. You're going to have to explain to them what they're supposed to do if the guide drops dead anyway. So it's not going to take long to show everybody how that works. And a sign is, of course, going to be there too. But
right.
You got to demonstrate how that phone works, or nobody's going to know what the heck you're talking about.
I suppose my chief worry in this situation is if they're underground, I don't want to inundate them with all of this. I quite frankly, at the high D, it's such a small mine. I'd rather they just go out. At some point, are you clouding them into too much responsibility? Left hand on the wall and exit is really easy to remember. Whereas you get into, well, left hand on the wall, unless you see a communication device. If you see the communication device, the procedure to use it is to lift the handle and hit the thing and make an announcement, wait for the portal watch to hear you. At some point, are we making this a little difficult for the everyday average consumer of our product?
We're making it simpler in an emergency situation. This is not something that we generally cover. We hate to have tourists to have to think about this, but because this has happened, this is kind of a necessary evil.
Well, I mean, you added something else in there, which I do think is necessary, and I don't think it's an evil whatsoever. We're trying to save lives here. It never really, the practical implications of losing the guide, it was such a major and drastic thing. I don't think it was anticipated. It wasn't by me anyways. But I think that's, out of all the contributions we have here, that's the most fundamentally important one we had, is to add something to our daily safety talk that we give before people underground that basically says, hey, I know this is unlikely, but it can happen. If I'm incapacitated, this is what you do. You simply put your left hand on the wall and vacate. Is rather simple. You add something and you want to use the phones, that's fine, but at some level, I guess my issue is just that when you're saying training and somebody's coming out of an MSHA environment, they're going to look for a lot more than did you casually mention it. They're going to want to see what has been established as a task trained event. So I suppose maybe I'm trying to look for a little bit of room where if there was an issue and there wasn't an accident and then somebody came back and did sue and they said, well, hey, I'm looking at your rules and I should have been trained on proper phone usage and I was never task trained on that. Sure, the guy casually mentioned how to use it, but I wasn't task trained.
And that's
there's some ambiguity here.
The point behind it, some of the requirements like the signage. You can tell a group, put your left hand on the wall and exit the mine. And there's some in every group, I guarantee it, that aren't going to hear a word you said.
Probably all.
and so, the redundancy of all the signs and instructions, that's why we want to see that.
The other thing I look at as well is if something happens, it doesn't necessarily need to be happening to the guide themselves. But let's say, for instance, it does happen to the guide, and everybody was instructed, put your hand on the wall and walk out. Where are they going to leave the guide, and how many people know that something happened to that guide? Are they going to start dragging him by the collar out? If they communicate by phone to the surface saying, "Hey, we got this person down, we need some help." That's all.
And everybody
Yeah, I
has
think
the
you
choice to
need-
save their souls. That's we're
I
just
like the
trying-
thought of including it. Don't get me wrong. I'm just wondering if we can change up the verbiage a little so it doesn't quite look like we need to train these people.
We-
Maybe something
We
a
know
little
you
less.
don't all have the same communication system. Some of them are very simple, like Capital Prize just has a phone with some numbers in the phone cover. And that's very simple. And a pager system is simple if you've used one before, but if you've never seen one, to Bill's point, there's some nuance to it. So there might be exceptions as to how much training you have to give.
So I've got a question. You mentioned something about training them along while on tour. Most of these phones, if they're placed correctly, are very close to the furthest point of the tour into the mine. It seems logical to me you should be training them before you go in the mine or at the portal. What's your
And I
thought?
agree with that. I agree with that. And I've seen a lot of them with the phone at the mouth of the portal. But it's I think through inspections and back and forth, we'll work that out.
So
I think it's going to be different at different mines. When we take people in on the train, they exit, they're 1,700 feet underground. There's a phone right there in front of them. And that's the place to do the training. But some mines, they're all going to be a little bit different. I think the intent here is to make sure we've got our butts covered. Your lawyer's going to say, you better do some training because just a sign isn't going to be adequate.
Right.
So I think, it just says training. It doesn't define that it's task training per 5023, yada, yada, yada. It's just training. And that could be simple in some places, a little more complicated in others, but it's got to be tailored to each individual mine.
Yeah.
Should we, on the word training, would it be different? Training / instruction shall be provided to all tourists on proper use of communication system.
I think it
That's what I was gonna
helps.
suggest, is just softening that language, either instruction or explanation shall be provided as opposed to training, if you think training's got more of a.
That's fine.
It'd make me
obligation
more
involved.
comfortable.
Okay, well,
You
we
I
we
agree.
took
guys
note.
all do a fantastic job of giving the history of the mine and it being no different than your airline stewardess. You just hold up your communication device and explain to them how it works during that period. I agree with Bill. It should be done before you go underground.
Oh, I agree too. I mean, and we're that scenario. We have it right at the mine. We mention it. If anything happens, you can come in and out. But did I train them or did I just tell them how to use it? And if somebody has an accident and they come back and say, "Well, you just told me how to use it. You didn't train me how to use it," and I wasn't able to communicate out, and that's why it seems easy until a lawyer gets a hold of it is sort of my issue. That's why I kind of like the idea of just changing the adjective: instruction,
Well,
mention, usage of phone. But to say that we're actually training them on anything, we're not training them on anything. They're coming up to enjoy a mine tour. They're not getting task trained or becoming proficient at any of these skills. And to ask us to give them that proficiency is, I think, asking a little bit more than what we should be required. Mentioning it, letting them know we have it, telling them how to use it. All of these things are fine. But as soon as you get into industry terms like training, I think that
instruction
you're
is
kind of
probably the-
pigeonholing us.
I think instruction is probably the more appropriate term here. We can likely make that change. It's just instruction shall be provided.
Yeah. Okay.
I think
I'm
it's a
fine with that. As long as you're doing it,
yeah.
we can call it whatever you want to call it. And it doesn't require that they sign a piece of paper unless you decide that.
Yeah.
Just
if you want to make that part of your waiver, I think it's a good idea personally. But, like I said, your individuals are going to hear it or they're not. You provided that information to them Whether or not they got it is on them.
Oh, no, I agree. I'm just, like I said, this is all in the event that something did happen and the lawyers are going over this form and they go, hey, training in a mining sense means this. And why didn't you do it? I say, well, we did. We talked about it. We mentioned it. Task training under MSHA guidelines
You're not
means,
under MSHA guidelines, though.
Yeah.
well, that's nice for you and I. I mean, like I say, if this was just non-litigious America, I'd say training is an acceptable word. I know what you mean. I know what you're trying to say. But in a world where you can be sued, I think that something a little bit more, or I should say less defined might be appropriate, because I think it's unreasonable for us to expect any reasonable competency out of any of this. And to say that we trained them is to say that there is reasonable competency. So I don't know. I say it's just I think you nailed it. If you could just change it to instruction, access, instruction on how to use, something that's not such a loaded term like training.
Yeah. All right.
But
Yeah, we can take a
maybe
look
it's
at
just
that.
me.
That's not a problem. So moving on, obviously, number 2, we just added must be installed, maintained, stuff that we do anyway, just to find a little bit more. And then for number 3, this is, this will be the one that will get, some of you guys will have to have 2-sided signs showing, the direction. And then, your communication needs to be up, within 50 foot of the end of your tour. So, I mean, not a huge change, but
I've got comments on that,
okay.
Brandon. 50 feet is not very far. The main room at the old 100 where the train disembarks and we have a phone there, that room is 225 feet long. And at some points we're about 180 feet away down another side tunnel in another area. We actually used to have a phone in the back part of the tour, and we discontinued that because basically you could hear the pager throughout the phone or throughout the mine without having a second one in there. So I don't know if this is something that we just work with the inspector on, or if
and
I was gonna
apologize. I don't mean to cut off, but
yeah.
If you look at the bottom there, it says petitions for modifications may be submitted to MSTP. So, I mean, you can submit a petition, within writing, and, well, more likely everybody's going to have an own situation that we're going to deal with. So, we're willing to work with you on that.
Okay, sounds fine.
I was just say that last sentence was purposefully included to kind of act as a waiver and exception process. We just want to make sure that all of those are identified, kind of part of the permit file, so we, show that they're either in compliance with the rules or they've been granted a waiver of that requirement.
Yeah.
So again, I think Brandon and his team will be somewhat flexible if you've got a good justification as to why 50 feet doesn't work in your particular circumstance.
Yeah. All right. So number 12, minimal change there. All we did was add all electrical equipment or components must be guarded or sealed from general public and have a ground wire or be properly guarded or grounded. Sorry, ground wire properly guarded. We'll get there. All right. So just adding a few little words. Nothing major there. Okay. Here, this is where you're going to see a lot of change. After CDLE came in, realized that the personnel hoist / we're changing to tourist mine conveyance. We're proposing to change it to that. We really don't have jurisdiction to be regulating that because we don't have the qualifications, and it actually falls under this Title 9, Article 5.5 of the State of Colorado's Conveyance Regulation 7 CCR 1101-8. Okay, so that's where it stays. We could argue this till the cows come home. I don't think that's going to change because we really don't have the authority to regulate it. Okay,
and this change was made in consultation with the Division of Oil and Public Safety, they're the ones that have regulatory authority over elevators, escalators, conveyances. And so I think majority, potentially all of the changes made in Rule 13 were based on their feedback and input. So this is very much kind of a jurisdictional authority issue as opposed to a change by the division.
Yeah. So as you can see on here, we kept some of the stuff. Obviously, the change of the language was actually done by CDLE. Okay. We did away with, we kept, I don't know, probably 6 or 7 of these. Just, so we kept number 10, 11, 12, 14, 18, 20, 21, 22, 28, 29. Okay, so we didn't change them. We changed maybe a little bit of verbiage here and there, but most of 13 went away. It dropped down to, how many was there? 11 versus, I can't remember how much there were to begin with.
Almost 29.
29. So that one, like I said, that's really only affecting the Hope Moore and the Molly Kathleen at this time. Okay, unless somebody else decides to put in a hoist.
Question.
Yes, sir.
Could we define conveyances operating at tourist mine facilities here? Because under the strict reading of this, conveyances operating to transport tourists could be anything from a tour bus coming down to the mine.
So we knew that was going to come
like
up.
a little 6-seater ATV. We let people, we give them a ride up and down the hill in the winter when it's slippery. That's a conveyance that's operating at a tourist mine to support members of the general public. Could we confine and define the conveyance to just being head frames or elevators or something of that nature?
If you read the statute, it defines it perfectly. Conveyance is takes one landing to the next. I think it is. It actually states it in there. Because that was a concern that Hank brought up, and we looked into it.
Okay, and that's the Title 9, 5.5.
Yeah, well, we can certainly, if it helps everyone, we can certainly add a conveyance definition to our definitions of these regs that mirrors that definition.
Yeah, as long as it's in there somewhere. I don't know
Yeah,
if we can add it or I want to read it and just to assure myself. But you see what I'm saying.
Yeah, and I agree.
I don't want to lose the right to tour buses and things of that nature.
I agree. I think we should define conveyance in this instance. So
Yeah, I think I would agree that'd be helpful. I did look at the state definition. Of course, we run a train. The train goes from point A to point B. It doesn't seem like it's defined as a conveyance, but if it was clarified, that would certainly be a good idea.
yeah, that's a good add. We'll go ahead and we'll mirror that definition. So it's just it basically says what a conveyance is and who regulates it.
Thank
All right. 14, no changes. Okay. 15, we just took out number 12. When actively involved in extraction of minerals or advancement of the adit, the tourist mine owner operator must also comply with any health and safety standards that apply to their specific operation as set forth under 30 CFR 56, 57, 58. Okay. So that's kind of, my opinion, is blanketed in with the point that we put a pin in. Okay. Enforcement provisions, we took out, this is basically talks about the cease and desist. Okay, and then we added, when an authorized representative division conducts any inspection and determines any condition or practice subject to the act or any violation of the act, those rules or any approved exists at a tourist mine operation, and that such conditions, practice, or violations create an immediate danger to the health and safety of the public or is causing significant harm, then such authorized representative shall immediately order a cease and desist. Okay, so that's where we kind of put back in there. And then down here in A, when an authorized representative determines that the cease and desist order pertinent to one above will not completely abate the immediate danger to the health and safety of the public or abate the significant harm or responsible exceptions thereof in the most extraneous manner possible. The MSTP supervisor shall, in addition to the cease and desist order, impose affirmative obligations on the tourist mine owner operator, training abatement of the danger or significant harm. The cease and desist order shall fix the reasonable time within which abatement shall be accomplished. Okay, so it's kind of a little rewording, a lot of the same information. Then we go into 2. This talks about conduct an inspection and determine that any condition or practice subject to the act or any violation of the act, these rules or any approved exists at a tourist mine, but the such condition, practice, or violation does not create an imminent danger to the health and safety of the public or significant harm, which is, so basically if we find it's not, we can issue a citation, basically.
So just for everybody's information, so this basically kind of helps the industry a little bit. And the reason why is the only enforcement action, we kind of learned this through the Molly Kathleen, right? The only enforcement action we had under our previous regulations was a cease and desist. If you were in violation, the only enforcement action we had was to shut you down until you came into compliance. What this does is it provides a section 1 that cease and desist still exists if there's an imminent harm. If there's imminent harm at the site, a cease and desist is appropriate. What we added was number 2, which provides the division the opportunity to issue violations. So let's say that your mine is out there and that you're in violation with some sort of regulation. That provides the division an opportunity to say, hey, here's a violation for rule whatever 8. That doesn't mean you're shut down. That doesn't mean anything. That just means you need to come into compliance with rule 8. It just provides a kind of an easy way to bring the site into compliance without a cease and desist. So that's kind of this rule was edited just to provide for violations rather than just a cut and dry cease and desist of a site. And so that's what 1 and 2 does. Now 2 also, if you get a pattern of violations, if you're a repeat offender, if, hey, we've been out here 3 months, it's the same violation nonstop, it's never getting fixed, then we can take that pattern of violations to a cease and desist. But that's kind of that's the premise behind Rule 16 and the revisions thereof, is just to add a violation portion of an enforcement action rather than just the solid cease and desist. We felt like that was probably inappropriate. Really kind of based on the Molly Kathleen. We learned at the Molly Kathleen that it was an operator error, but we had a cease and desist. Like we shut the whole mine down for something that didn't turn out to be a violation of our rules. And so we want to kind of have that leeway to just have violations versus a cease and desist. So that's the premise behind this.
And importantly, I mean, I know notice of violation sounds ominous. It sounds like there's heavier weight behind it. There are no civil penalties here. We don't have the authority to issue civil penalties for violations. It's just they're in the enforcement context. That's just the language that's used by other parts of the division is a violation, either an abatement or a corrective action to get things remedied. Violation is then cured and you go on about business. As Jason outlined, if you fail to cure or abate that violation, then it could lead to a cease and desist. But I wanted to clarify, there are no civil penalties. There's no kind of monetary impact from this. It's just a violation that eventually leads to a cease and desist if it's not fixed.
All right, any comments? All right. Number 3, a person who is issued a notice of violation. Okay, I think this talks more about it. This same thing.
Yeah.
Okay.
I think just for recognition purposes though, too, we might mention that a violation will appear on an inspection report. I don't know if we have a separate form for that. So that's where you need to be looking. If we do discover a violation, it's going to be the same as it was before. up to a certain point, I think that, we'll just mention it on the inspection report. We're not going to issue a separate piece of paper for violation at this point.
Right.
That's right, Hank. And to clarify, appreciate, Hank, for full transparency, when our folks are out there, Hank or Tom or Brandon or anyone's out there, it's going to be full disclosure. So it won't be shocking when you see on an inspection report just this violation. Like, everybody's going to know everything. It's probably going to be agreed upon. Hey, yeah, I need to get that fixed. It's just for documentation purposes.
Yeah.
Is why it would be on the inspection report.
And when the permit system goes live, everything will be available online as well.
Chris?
Would it be possible to have it on a separate piece of paper so that it's not on the inspection report? Let's say you come up and you see something that's out of compliance, say just for example, your fire extinguishers, anything though, really. If you could say, well, this is out of compliance, here's a temporary issuance of enforcement, you have 90 days to get it under compliance, and you so do. We will then come back and issue your yearly inspection report, and it will not have that you are out of compliance. So that if something were to come up in future generations, they can't see every small mistake like that in a litigation setting. If we fixed it and it wasn't anything that was deemed so dangerous as to be a danger, can we, for lack of better words, keep it off of our permanent record?
Well, Chris, I think to that point, the division, I'll just give you historically in our other programs. Historically, let's just say you have a fire extinguisher out of compliance. I would expect the division to not write a violation for that. A violation is going to, so you're getting into some nuances. And with our other programs, you got these nuances between a maintenance item and a violation. If you go out to any mine site, including a tourist mine, you're probably going to find a violation. You're going to find a violation at every single mine that we have in the state, at least one somewhere. But we can't operate like that, right? We can't operate in where we go out and write 15 violations every time. You have to make a determination, is this a violation of an act and a rule, or is it a maintenance item that can be remedied by the next inspection? And so if you have a violation, and remember that everything we do, whether it's on a different form, whether it's on a inspection report, is all correlable, right? So anybody can see it. It's all public record. That's the way it is. We can't change that. And so, but there is some leeway there. If Hank goes out and he's like, hey, this is a maintenance item, we're not going to, can you get this done in 30 days? Like, send me a picture that you got this done. Then it doesn't go on an inspection report, doesn't go on anything. You just get it done. Now, if you go out there and there's something that you can't get done for whatever reason, and it's a violation, a strict violation of a regulation or a statute, then it's going to, whether it's on a different form on the inspection report, it's still got to be documented. So that's the difficult part. But I can tell you that because of this rule, we're going to function pretty much the same. This just provides an opportunity to avoid a cease and desist and utilize a violation if we feel like this whole site doesn't have to be shut down. And to that point, a whole site doesn't have to be shut down for one expired fire extinguisher or a loose wire on a phone or something like that. So yeah. I hope that kind of clears it up,
And to Jason's point, Chris, too, we have the ability to apply, compliance assistance. So something little like he just mentioned, maybe some exposed wires that need taped up, maybe something that you can do before I leave that inspection. I'm not going to put it on the paper if you can fix it that day.
Okay.
And other things, at our discretion, if it's a small thing, it's not going to take 90 days to fix. I'll say, okay, I want this fixed. Tell me how much time you need to fix it. And if, 2 or 3 days down the road, you have my number, you can send me a text with a picture that you fixed it. I'm not going to worry about it.
Little
is that fair?
flexibility and a lot of common sense getting
Right.
applied. That's
Exactly.
good.
Yeah, exactly,
Well,
Chris.
in addition to that as well is by the reports that we fill out and we file is Hank may not be the same guy that goes and inspects at mine. It may be me or maybe someone else. So at that point in time, by reading the other inspection report that he made is now giving me some indication that there were some issues that got corrected or need to be looked at again. So that's additional information for us as inspection that whenever we go do an inspection, that is going to help us and along with helping the operator, making sure that, you know, everything did get taken care of.
Okay.
All right, so on into 16, we basically removed the I guess it had been number 5 at the time. It moved down. Any decision by the DRMS director after hearing on an appeal of an order? Okay, that was all kind of taken out of there. All right. Rule 17, no change. Rule 18. So that's it. So any changes or concerns that we did not list or cover?
Hey, Brandon, just one more minor thing. You know, on the annual report, which is now done online, I think it would be really nice to have a blank text block where general comments could be put in.
Okay.
You know, back before we had that sort of form, and I used to send a letter in, I usually summarized the changes or improvements or maintenance items from the prior year. And it would be nice to have a place to be able to say, you know, hey, we replaced, 300 feet of rail, or, we rebuilt such and such a piece of equipment. And then it sort of gets it in some permanent form that, somebody can go, well, yeah, a couple of years ago, they rebuilt that locomotive or whatever. And right now, there's really nowhere to put that kind of information. And it's just whatever the operator might want to put in.
So this, this Google Doc that I created, it's just a test trial. We'll try it again next year. We may find it's too onerous and it's not applicable. It's just as easy to email it to Kim. And then we put it up into the permit system, but all that stuff will be housed in the permit system once we are fully live with it. So I mean, that's really what the deadline is for, so we can get that and make sure it's all up to date, things like that. So, at this point, this is just a trial. If you guys don't like it, at our next tourist mine meeting, we'll chat about it and see. And if you like the way we did it before, we can look at possibly doing that again, or making it some other way of where you can just upload a document versus trying to fill out a Google Doc. So we're trying to make it easy on the operator is what we're trying to do. So, and capture all the data that we need. So.
We want to talk about timing.
Could I add just one more thing while we're talking about violation?
Sure.
Just while I have those of you that are here, I just want to get the word out. We email these reports back out to you, and I've been laxed in how I've done it. For future reference, when I email an inspection report out, I'm going to add a receipt request. Would you please let me know that you received those? I've fat fingered a couple of emails. I've had some incorrect emails given to me, and so I don't know if you guys actually receive them. This really helps, especially when we come back out. If you have no idea what happened at the last inspection, it doesn't help you either. So please let us know if you got them. Tom and I are going to start adding read receipts to these. So please let us know you got them.
Yeah. And if you've had an inspection and you haven't received it, feel free to reach out to me. We'll follow up. We'll make sure you get it. There's unfortunately, with it all going online, eventually doing it digital only made sense So we will need that. We can't give you that hard paper copy anymore just because we don't have the printer access while we're out on the field. You know, but we're gonna work hard to try to get it the next day or, you know, within the next couple of days for you, you know, so that's our goal, and hold us accountable. We'll try to do our best and make sure that, make sure we don't leave that property without knowing exactly what is gonna be on that report. Okay, and then that's gonna be on us. We're gonna make sure that we ensure you that, hey, this is going on there, this is going on there, this is going on there. You know, but make sure you know you're aware of that as we leave. So you won't have to wait for that report to start fixing your problems. You should know it before we leave that operation.
So in terms of timing, Chris, I know that you're getting everybody together on kind of a Zoom call just internally. What's the timing? Because what would be nice is if, whether we're involved or not, is to have another stakeholder meeting where I mean, you saw how quick we ran through these minus the dual use, but so just narrowing down that subject, having another stakeholder meeting, see if we can hash out some things. We're going to make some changes internally. We're going to, of course, look at some things. Then when we get together, we can present those things. We'll obviously present them before we get together, but we can discuss it prior to any hearing that we have. So I'm just wondering what kind of timing you would think in the next 2 to 4 weeks for you guys to get together, and then we could set up a stakeholder meeting, and then that would give Michael, the division director, kind of an opportunity to set or continue the rulemaking hearing to a later date.
Well, I say the only real issue is running through the holidays. That always
exactly.
makes it hard to get everybody on the same page. I guess my immediate thought was just that, send an email out to everybody and see if we could get together. I'm not sure if sooner or later is good. I mean, I guess good as time as any to ask. We've got the key players right here anyways, the people that bothered to stay to the end of the meeting. Anyhow, I feel like most personally, and jump in, guys, if I'm wrong here, but most of my major issues were nailed when, you know, you're going to add the new in there on the fire, because I don't want to redo a portal that's been in existence for over 100 years and not add a fire issue. Most of it, other than the one we buttoned, seems to be pretty well handled. And I think a lot of how you guys are going to handle the changes on that button issue is going to dictate how much how much comment you're going to get from our end. Just like we saw today, that does seem to be the major issue. And we spent an hour and a half on that one roll and an hour and a half on all of the others. Right. So between the you know, half dozen of us here that aren't on the state's page, do we want to try to get together ASAP after this so that while it's all fresh in our heads, we can get down what we need to do? In which case I would recommend we just even utilize this same structure. Well, probably best to do our own meeting, maybe, you know, within a week. Or would we prefer to do a meeting in, say, 2 to 4 weeks and give everybody a chance to email each other and throw some of these written comments down? Just a quick run through everybody here. Maybe we can start with whoever wants to start, but any preference here or a third option that I didn't hit?
Let's pick a date, Chris, right? For everyone, let's do that. I mean, you know, most of us are on here now. Let's just pick a date where we can talk offline or off of this platform, and then.
Yeah, I mean, my only, with just a little bit of time, so that if we can get a few of our missing ducks back in the fold, it'd be nice too. I know my uncle was supposed to be on here, but he's constantly with computer issues. I wouldn't be surprised if that nailed a few others too. Bob Calder isn't here. I know he was invested. So we do got to try to round up a few of our other missing folks.
You want to
But
try to do a call like next week, set up a Zoom next week that's before the holiday week, right? Is that fine for everyone on here?
That's good for us. I'm very flexible.
Might as well do it now that it's like we're refreshed on what's going on versus like,
yeah,
you know.
I agree.
well, it's like I'm just putting the calendar up on my other screen here. Let me take a
You've got
quick.
like, I don't know if any days work better for everyone, if it's like midweek but you've got 18 and well, the 20th, I'm on a flight actually coming out to Aspen to meet these guys, but the 18th, 19th, Tuesday or Wednesday,
I'm fine with either of those.
either of those.
So the
Tuesday.
19th is the date that the hearing
Yeah,
was set for.
They don't work for me either of those days.
Either of those don't work
Are
for you?
you doing
Okay.
mine rescue, Dave?
No, I'm doctor appointments.
What about this Monday, the 17th?
No.
That's quite good for me.
Okay.
Or no. I'm on paternity leave. You guys pick a day. I'm good with any day.
You are? Okay.
Yeah.
Chad Parker, what'd you say?
We can't do Monday. Pretty much the rest of November's tied up with our mine rescue training.
This coming up Monday, Jay, not the following one, the 17th.
Right.
Yeah, Chris can't make it.
As long
Boys
as
can't? No.
Early might be able to do it.
I can do it early morning, but I have to leave by 11.
Yeah, early's fine. If we can do like 9 a.m. or it's 8 a.m. I'm sure everyone's up early, whatever works for everyone.
9 a.m. is appropriate.
Yeah, 9 a.m. Chris.
Yeah, you want to do it at 9?
The 17th, 9 a.m.
I'll be able to give at least an hour and a half, and I think probably in the hour and a half, we should be able to cover a lot of it, didn't we?
I think so.
Okay, good here.
All right, everyone else on here? What do you got? Everyone's muted.
I'll make the 19th or 17th work at 9.
So we'll send out a blanket email then, just to everyone, and hopefully everyone can jump on or at least give comments if they can't make it. We'll talk around it.
Yeah, that's just it. Even if everybody can just email or throw through some emailed comments. But tentatively then Monday the 17th, 9 a.m.
Yep, that works. Yeah, Chris, you got everyone's email, I think, right? You have all the miners on that.
I hope so. If, like I said, I gave my email, so if you didn't get that first email, did you get it? I think you're on there, aren't you?
Yeah, everyone. I think there were like 20.
Yeah, so if you didn't get it, email me and you'll make sure you're on the next one. But I'm gonna we got nothing to hide here. I'll just use the same list. That way, at least I know you guys will get it. And if anybody gets added, I'll just keep adding them. But
that works.
There you
go. Thanks everyone.
Thank you. Appreciate it.
Well, the one thing I was going to say is what we'll do just in terms of the state, we're going to make those small changes that we talked about after our the topic that we tabled. So we will put that out. It's going to be small, short, because you guys had some great points. We're going to make some changes internally, do that kind of thing. We'll probably make some changes, or at least maybe make some potential additions on a draft that speaks to the dual use. So the one ask that I would have is just when you guys meet next week, you guys just can memorialize your thoughts into kind of one distinct thing. Maybe we can get that addressed before the next stakeholder meeting. So we get in that meeting, we can all come to a consensus. We're all on the same page. And then when a hearing happens, there's no surprises. We're all good with everything. So that would be my only ask.
Yeah, I mean, I just say, well, I'll kind of send out something to everybody vis-a-vis that email that kind of gets over the points that I found in my notes, and anybody can add to it. Once we've got that put together, we can send that off to you. You guys can get a look at it, and then we can reconvene this in a draft setting and make sure we're all on the same page, and then maybe look towards setting up your formal request. You used more proper words.
Great. Yeah, that's perfect, Chris. And like Jeff mentioned earlier, we are going to hold our rulemaking hearing, but that's just so the division director can continue it to a later date.
Yep.
So the process stays in line. So
continued.
Yeah, exactly. So with that, I can't tell you how important this process is. And that all of you were involved in it. It's vital to make sure that we get these things right and that your voices are heard. And so I really, really appreciate that. You would be surprised at a lot of these rulemaking hearings that the number of people that don't show up and then complain later. So really appreciate all the work that you guys are putting in. I really appreciate that. You guys are going to meet and get some more information on paper. So I appreciate it. Brandon, do you have anything else before we conclude?
No, once again, we appreciate your time and we know everybody's busy and like I said, thank you again.
Great.
Yeah, thanks all.
Worth it just to see you in a suit, Brandon.
I'll come inspect in the suit from now on. How's that?
It's snazzy.
Yeah, Brandon, I just don't recognize you.
Well, get used to it, buddy.
You get it.
Thanks, everyone.
All right.
Good to see everybody. I'll send you that email.
Thank you.
Yeah, send it out. And then, Chris, I'd assume you're going to set up the meeting.